Year-old postal worker Chevelle Lassie is suing her former landlord, 48-year-old computer administrator Kenneth Strickland, for the return of rent and a water bill. Kenneth says Chevelle lied on her rental application.
Order. All rise. Now, this is case number 502 on the calendar in the matter of Lassie versus Strickland. Parties have been sworn in. Judge, you may be seated. Sir, have a seat, please.
Ms. Lassie, you were a tenant of the defendants for 2 years, according to your complaint, and you claimed that for 2 years you overpaid him in rent.
Yes.
And you want to be reimbursed for that overpayment.
Yes.
The defendant seems to say that you caused all the problems yourself, and he owes you nothing. So let's get some dates and facts. What kind of property was this? Was it a house or an apartment?
No, it was a house.
And when did you move into the house?
November 7th, 1998.
Did you have a lease?
Yes.
May I see the copy of the lease? Who moved into the house?
Me and my 2 kids.
Was that all the people who lived in the house?
Yeah, my boyfriend used to be there, but he didn't live there.
You still have the same boyfriend?
Yes.
How old are your 2 children?
11 and 8.
Is he the father of those 2 children?
No.
But he was your boyfriend in 1998? Where does he live?
In L.A.
And who does he live with?
His sister.
Right.
Huh?
Right.
Right what?
Just what I said. Right. All right. So you, your 2 children, and your boyfriend were there most of the time?
Well, he always was in L.A. because it was so far. So some nights he'll come over and sleep over, but mainly he was in L.A. by his mother or his sister because, you know, it was too far.
Right. Okay. This is not your lease, madam. What you handed me here, at least the first page of it, unless there was another lease.
That's the whole contract from Section 8.
I'm not asking you for the contract from Section 8
Well, that's
housing.
the only lease that I have, because that's how I got the house through Section 8. And that's the only lease that I have.
What was the entire rent that you were supposed to be paying pursuant to this lease agreement voucher program?
It's on one of those pages that's right up in there, 219.
It says the housing subsidy payment is $581, and the tenant's monthly payment shall be $219. Now, did the landlord get this $581 himself, directly from the state?
Yes, that's the contract.
Did you get
from
that
Section
directly
8.
from the state, $581?
Yes.
Okay. And she was supposed to give you, according to this, $219.
Yes.
Now, you moved in November 7th of 1998, and when did you vacate?
I didn't vacate till January the 9th when he moved my stuff out illegally.
Just a minute. January the 9th
Yes.
of 2001.
One.
And what rent were you paying?
For the whole, okay, I was paying $219 up until April 1999.
Okay, so up until April of 1999, you were paying what you were supposed to pay.
Yeah, $219.
And then what happened?
And then he said that the rent was going up, that I had to pay him the $620.
When did he tell you that?
That was in, I think it was March, because I have the first receipt that he handwritten right here for the $620.
So you started to pay him $620
Yes.
in
April, here you go, right here.
April of
1999.
in May of 1999. You said you paid him in April $219.
Not April, here you go. February the $219, here you go. And this the one April for 1999 for the $620.
Okay. So in April of 1999, you started to pay him $620.
Yep.
Okay. And did you pay him the $620 from April 1999?
Yes.
Until you, you didn't hear my question.
Okay, I'm sorry.
Did you pay him the $620 each month from April of 1999 until you vacated the house on January 9th of 2001?
No, I paid it from April till October. After October is when a big dispute came about. In November was when he said, don't pay nothing the rest of the 2 months while you're there. See, if I get to tell what really happened, then you'll see why. Nothing got paid in November, nothing got paid December, nothing got paid January. I was supposed to move out January the 21st is when he went in my home on the 9th and removed all my property, put half in storage, left half there.
I don't care about your property, madam.
Okay, well, that's
not
what
the
I'm
subject
saying.
of this
That's what
lawsuit.
it-
I'm only asking you about when you paid rent.
Up
So you
until
didn't-
October.
Did she pay in October?
She paid all but $120 of the $620 that she was paying me.
I gave him $500.
Just a second. But she still was overpaying?
I don't want to answer that question until I present my side of the case, ma'am.
Okay. Well, at least according to you, Miss Lassie, you paid for approximately 18 months, an additional $401 a month.
Yes.
That comes to $7,218.
Yes.
Which exceeds the limit of this court. You understand that?
Yeah.
Limit of this court is $5,000. Okay, let me hear the story, Mr. Strickland.
On 9/26/98, Chevelle Lassie, she filled out an application rental for that home that we were speaking of. And I thought the application looked good. It indicated that she had a job making $3,800 a month. It also indicated that she was had a voucher program. She had a car, a 1998 Mustang, and her Social Security number was on there.
Do you have a copy of that application?
Absolutely.
Can I see it, please?
Okay, I'll just sample it. Rental application. I felt that it looked good, and we got together. We talked about renting the house. We made an agreement, signed a rental agreement prior to the section or the housing agency, and that's this right here.
May I see it, please?
And I was under the impression that she could pay that amount since she, expressly signed that contract. About a month later, the situation broke down as I got the information from the housing agency that she couldn't pay $1,251 and that they would only allow $800 because she didn't have a job. She was on welfare. And so that struck me kind of odd. So I called her up, went over there, and I asked her, I said, well, they're not going to allow you to have the $1,251, and I thought that you had a job that could to pay over this voucher amount. And so I asked her why did she lie on the rental application. He says, don't worry, we're going to pay you. And I said, what do you mean we're going to pay you? And then at that time, her boyfriend came out and he says, Ken, we really like your house, man. Don't you worry about it. We're going to pay you, I said, well, I don't know about this because, I spent a lot of money getting this house prepared, and I also thought I had got someone in there that was truthful and honest, and that didn't turn out to be. By that time, I felt that this person was living there. Not only that, I noticed that she had 3 dogs, 2 out in the yard, 1 in the house, and they also had a bird, which was strictly prohibited by, the contracts that we signed.
So why'd you evict her?
Because it was a very tight spot for me.
No, it isn't. No, it isn't, Mr. Strickland.
No.
Real cases, real people. Judge Judy. Chevelle Lassie says former landlord Kenneth Strickland overcharged her for rent. Kenneth says Chevelle lied about her qualifications for Section 8.
Listen, were you working at air conditioning?
Yes.
On whatever date you filled out this application. Let's
Yes.
see, you filled out this application
9/26/98.
9/26/98. You were working there?
Yes.
And you were earning $3,800 a month?
Yes, because I was working at Federal Express, too, during part-time.
Just a second. You were earning $3,800 a month?
Yes.
Why were you also getting a housing subsidy?
I've been getting housing since I was in New Orleans. And I transferred my housing here, and if you work, that's all they do is make your rent go up some or make it go back down. That's all they do.
You mean if you're making almost $4,000 a month, you're going to get somebody else to pay your rent?
You can be on Section 8 and make good money, just that your rent will be higher. If you're not working, it goes down. So then when I wasn't working, it went all the way down. Because once I moved to Palmdale, I wasn't working at air conditioning no more. I got me another job.
Working for whom?
It's a warehouse place.
And how much were you earning there?
I don't have the total figures in front of me.
Well, give me an idea. Were you earning more or less than $3,800?
I was making less.
Did you tell him that you were going to change your jobs?
Oh, he knew where I was working.
Make $4,000 a month, and the boyfriend lives there, too. What kind of work does he do?
No, my boyfriend was not living there. He was not living there.
Yeah, right. And your obligation was $200 a month?
$219.
$219 a month. That's a very good deal. Most people these days pay at least
Well,
a
that's
third.
what Section 8
I said to you,
approved it to be, $219.
this is a wonderful America. You can just transfer your Section 8 wherever you go.
Yes, because I have a voucher. I could transfer it anywhere I want.
Yeah, isn't that wonderful? Listen, it doesn't relieve you. You know the score. You're a smart man, right? You sign an agreement with Section 8 housing? Sir. Yeah. And your agreement with Section 8 housing is clear. This is what you collect from us. This is what you collect from her. Her obligation is $219. What you're telling me now is you entered into a side agreement with her that she would pay you more than the $219 if she really wanted the place. Is that what you're telling me? But that's prohibited by Section 8, right?
That is prohibited.
That's prohibited by Section 8. All right, but she still didn't pay rent for 3 months. Any rent for 3 months.
Because Section 8, this is what happened. He called me one morning in November, in 6:30 in the morning, and told me because Section 8 didn't pay him his $581 because he didn't do some work that was done in the house when they came to inspect it, that if I didn't pay the whole $1,200, that I had to get out. I told him I was not paying it. I'm going to just move. Went to Section 8, told them what happened. That's when my worker let me know, no, you are not liable to pay what we do not pay him. But he had me under the impression that I was supposed to be paying him the whole amount that they didn't pay him, and it was a lie. And when I confronted him about it, oh, well, that's what Section 8 told me. I said, no, they didn't. You was just trying to get my money. So I let her know I had been overpaying him the rent, and she the one told me to call legal aid to get advice on it, how to sue him to get my money back. And
did you file tax returns last year?
No. Wait, did I file what?
Tax returns
Oh, yeah, I'm sorry. I'm sorry.
How much did you earn last year?
I don't know. It's on the papers. I don't have them with me.
Everybody knows how much they earn.
Let me see. About...
Everybody knows.
It was like 20, 24, 25, something like that. I don't know the exact amount.
Drive a car?
Yep.
What kind of car do you drive?
A Toyota Camry.
What year?
1988.
What happened to the Mustang?
I don't have it anymore.
What happened to it?
I sold it.
Well, you were driving a new car. A 98.
I just decided that I didn't want it no more. One of my friends took over the notes on the car. I went to the auction, got me a little 1988
Just a minute.
Camry.
So you were paying out notes on the Mustang in 1998 when you filled out this rental application. Yes. And how much was your car note?
With insurance and everything, it was like $451
a month.
Yes.
So you're paying $451 a month for your Mustang, and you're paying $219 for rent.
Yes.
You're in the wrong business.
What you mean the wrong business?
You're right.
I mean, I had help, so I mean, what's the wrong business? I had a boyfriend that was helping me out. I mean, what's the wrong business?
The problem is I got 2 people playing the system, right? I got 2 people playing the system, and certainly Mr. Strickland, I mean, his excuse was that he was lied to on the initial application.
No, he was not.
And that's, yeah, he was.
No, he was not.
He was.
I was working at air condition. I wasn't even on the county then.
You are on the county is when you, listen, madam, when the government pays your rent.
Okay, well, you can work and have Section 8.
I'm speaking, when the government pays your rent, that means you're taking money from the state because you can't afford to pay your own rent. People who can't afford to pay their own rent don't spend $450 to drive around in a Mustang convertible.
Judge, when I got to Section 8 in New Orleans, I was not working. I transferred my stuff here. You are allowed to work and get Section 8. You are allowed to work.
I didn't say that you weren't, madam.
I mean, well...
I didn't say that you weren't allowed to work. You are allowed to work and still get assistance if you're not earning enough money to pay for your rent. What I'm saying to you is if you can afford $450 a month to drive around in a new car, then you don't need that much money to pay your rent. That's what I'm saying. You don't get that? No, you don't get that. Now, Mr. Strickland, who filled out this application?
Can I see if that's...
Chevelle Lasai filled that out.
Okay. Did you call her employer, sir, to check these references?
I did call her place of employment, and they did verify that she worked there.
For 4 years?
Yes.
All right. Now, Mr. Strickland, let us assume that this is correct. This was not misleading. If you called and verified that she was working there, then she didn't fill out a false application. She may have changed her jobs later. And she did, in fact, have this 1998 Mustang. So why is this false?
Social Security number is wrong.
Oh, you're full of baloney. You're a smart guy.
Okay, I have...
You're a smart guy. What difference does it make if the Social Security number was wrong? What substantive difference does it make? She gave you her name. She gave you her address, how much rent she was paying, where she was working, how much she was earning. You called and verified where she was working. She did, in fact, have the car at the time. So your defense to me initially, at least in your answer, Mr. Strickland, was that she lied initially in her application. I don't see any lies here.
Okay, could I continue then my...
And do it fast, sir.
Okay, soon after she moved in, like I said, the agency said that we signed the agreement, and however, when they had told me that she wasn't capable of paying it, I went to her, and as I said, we talked about this, and at the time the guy came out, he says, we are going to pay it. Then they had 3 dogs there. They had a bird.
I got 3 dogs and a bird. Yeah, go ahead.
And I said, shh. And I told him, in no uncertain terms, I said, because you are breaking the lease, you know, I have to charge you damages on a monthly basis, and that's going to be $451 plus the water, trash, and everything else. And she agreed to do that.
That's not true, Your Honor.
Doesn't make any difference, sir. Sir, you know that the rules state the contract you signed with U.S. Department of Housing and Urban Development are clearly specify that you are not permitted to charge her any more money. Now, if, Mr. Strickland, you say to me that she was going to pay you $219 and that you had an agreement with her boyfriend and you could establish that he was living there, that you had an additional agreement, that he was an additional tenant in that property, I may say, maybe. But you knew that you were breaking the law by overcharging her. You knew that. The fact that she shouldn't be receiving this money to begin with irritates me as a taxpayer. Big time. Big time. Because she says, well, they just transferred from New Orleans to where I'm living.
They did.
Well, she's a little bit smarter than that, Your Honor.
That's not true.
Listen to me. She's very smart. She's got the system worked out fine. She's got the boyfriend who lives there. The 2 of them work, right? And the total income that they have, on their total joint incomes, they pay rent of $219 a month. And at the same time, I'm sure he has a car. She's driving around in a new Mustang, right? Taxpayers are footing the rest of the bill, $580 a month for her rent that we're paying as taxpayers. So believe me, I understand that she's got it down pat, but you broke the rules. And unfortunately, as unfair as it may sound to me as a taxpayer, you are responsible for this $5,000, which is the maximum that I can award her because she actually overpaid over $7,000 in rent. So I have no choice, sir, but to enter a judgment for the plaintiff for the amount of $5,000. And I want to tell you something. It breaks my heart. Thank you. That's all.
Pardons excused. You may step out.
40-year-old contractor Patrick Wirtz is suing his ex-girlfriend's mother, 43-year-old daycare provider Catherine Heath, for the return of a camcorder and the cost to repair a wall. Catherine says the camcorder was purchased by her mother.
Order. All rise. Yeah, this is case number 504 on the calendar, the matter of Wirtz versus Heath. Parties have been sworn in. You may be seated. Ma'am, have a seat.
All right. Mr. Wirtz, you and the defendant's daughter, I assume this young lady, have a child together.
Correct.
And you were living together. You're not married.
Correct.
It is your complaint that at the time you split up, the defendant, grandmother of your child, came into your home, took a camcorder that belonged to you, and also that she damaged the walls in your home by taking off some shelves from the wall. That's your
Correct.
complaint. Defendant says that A, the camcorder wasn't yours to begin with, and she's got a story about the shelves. Okay, how old's your baby?
Year-old.
And when did you separate from baby's mother?
End of July.
Of 2000.
Yes.
Is that when she moved out?
Yes.
Was this your apartment or home that you were living in?
It was our house, renting it.
Are you still living there?
No.
Let me hear about the camcorder first.
Okay. I purchased a Sears camcorder on my Sears card. I guess Michelle had some money that came in the mail through her grandmother. Michelle wasn't working time because she was, I believe 8 months pregnant. We spent that money on her part, paying her part of the bills, her half the bills, her part of the rent, and her part of the utilities. I don't know what the circumstances were her mother paying for a camcorder, including she didn't have a job at the time.
Let's just a second. Don't get to her defense first, sir. You're talking
Sure.
about her defense.
Sure.
Let's talk about your claim that
Okay.
this was your camcorder that you purchased.
Sure.
When did you purchase it?
10/22/00, so October 22nd.
Okay, and how old was the baby at the time you purchased it?
He was not born yet. He was born February 7th.
You purchased it in October of 2000.
Yes.
You say your baby is a year old.
Sure, I guess he was born, wasn't he?
When was your baby born?
February 7th of 2000.
I guess he was. I guess he was 8 months old at the time.
Okay. What made you decide to purchase this camcorder? Look at me.
Sure. Just to have a camcorder and build my credit, because I had no credit at the time, and I did get a Sears card
When did you get the Sears card?
about a month before I bought the camcorder.
And you were working at the time?
Yes.
Was yours the only source of income in the house?
At that time, I believe so.
What do you mean at that time you believe so?
I believe so. I can't tell you for sure because she just had the baby and everything else, and she was going through her jobs and her problems.
Would you step up with your mother, please?
Yes, ma'am.
Tell me your name.
Michelle Went.
Michelle, were you working in October of 2000?
Yes, ma'am.
Who was taking care of the baby when you worked?
My mother.
Okay. Now, Miss Heath says that your grandmother, the baby's great-grandmother, had sent
Yes.
a check for $400.
Yes. I have the check right here. With
And
the
that-
card that she mailed after my son was born.
And I'd like to see it, please.
I signed the back of the check when I received the check in the mail. I deposited the money into his checking account. We had nothing joined. As you can see, he signed the back of it, and it went into his account for the purchase of the camcorder when we were ready, after we had picked out the one we wanted. My grandma mailed me the check for the purpose of buying the camcorder because she lives out of state, so we could record.
Take pretty pictures with the video camera. I can't wait to see my great-grandson. So she sent this check for the purpose of buying a camcorder, right?
Suppose so.
Suppose so. And you took the check and deposited it in your checking account?
Sure.
Okay. So you went out and bought a camcorder. When you separated, you took the camcorder.
Yes. I put a deposit down on an apartment in Tesca where my mother lives. Under the circumstances, my son was abused, and under the circumstances, I was advised by my attorney to leave the household because of the suspects and whatnot, what was going on. So I packed my stuff that afternoon while he was at work in fear that I didn't want conflict when I moved out. He knew I was moving. I told him I had a desire to move. I got my belongings. The camcorder, I had took that long time ago. I put it over at my mother's house because I knew that when it came down to it, it was about material possessions to him. You know, it's not about that.
Okay.
You know, this is under the circumstances with the abuse of my son.
What kind of abuse?
He was spanked.
Open hand, diaper off hand,
Black
an
and
adult.
blue. Black and blue.
A doctor noticed it, and they...
That day, my son had a routine checkup, and I took him to the doctors, and I discovered this.
How old was he at the time?
4 months. 4 months old. Sorry.
And you moved out immediately?
Yes. Shortly thereafter, I took my son's belongings and my clothes on my back, and I left.
Okay. The shelves, Mr. Wirtz, your complaint is not that you removed the shelves, which I understand that Miss Heath made for the baby, but that when she removed one of the shelves, it caused damage to the wall.
Correct.
And you want that damage paid for.
Correct.
So let me hear about the shelves.
Okay, I'm not disputing that I did do any damage. It did. The shelves that I made, I had put brackets on them, and I have pictures of that, where the brackets were a foot, exactly 12 inches apart, to hang on the wall. And I took the one off and gave it to my father. He loaded it in the truck. I went to go grab the other one, and that's the picture of the other one. And I pulled it off, and it did do some damage because there is a screw. If you noticed in the pictures, there's a drywall screw through the wood that was put into the wall. And I did not know this at the time. I didn't mean to do the damage.
Okay. Do you have an estimate to the damage to the wall?
Yes, I do. I have an estimate from a contractor in Salina.
Okay. And also, he did do the repair,
There's a picture of the wall.
He fixed the wall himself.
and he got
How do you know
$100
that?
back.
I know that because I went
And he told
myself before this court date and talked to the landlord.
Plus, he told you, didn't he?
Plus, he told me. He told me he fixed the shelf because he couldn't move out without fixing it.
Did you fix the wall?
Yes, I did.
Did you fix it yourself?
Yes, I did. There's an estimate from a contractor. Same way, he'd charge me for doing it. I can't pay $540 to have a wall fixed.
Just a minute, so you fixed the wall yourself?
Yes, I did.
Well, how much did it cost you
I
to fix
never
the
said I
wall?
did not fix it myself. I did fix myself.
Just a second. So you fixed the wall?
Yes.
Get out of here.
Parties are excused. You may step out.
Be a father, and that's all. That's all we want for him.
It's a continual war between these two.
It is very important for him to be a father to the baby.
I've always said he was a good father.
And now the next case.
All parties on Meckler versus Virgin. Step forward, please.
51-year-old stockbroker Ronald Meckler is suing his ex-fiancée, 41-year-old accountant Catherine Virgin, for the cost of items purchased for their townhouse and the cost of an airline ticket.
Mr. Meckler, you and the defendant had sort of an on-again, off-again relationship, according to your complaint, for a couple of years.
Correct.
You resided in Houston, Texas.
Correct. Still do.
Ms. Virgin, you resided in Portland, Oregon.
Correct.
According to your complaint, there came a time when you decided to relocate to Houston. You thought that you would have a long-term relationship and you were going to look for a job there. It didn't work out.
Correct.
So you went back to Portland.
I had an opportunity to return to Portland, and I did so.
And at that time, Mr. Meckler pursued you.
Correct.
That be a fair statement?
It's very correct.
And Ms. Virgin said, listen, I'm not coming back to Houston. You want to do the relocating this time, you come to Portland.
That's correct.
I mean, I'm reading between the lines, but that's pretty much what I'm getting. So you did. You came to Portland, Oregon, and proposed marriage.
Correct.
And you indicate in your answer that you were caught up in the moment and said yes.
Yeah.
Judge, the acceptance of the proposal was done as almost in a public spectacle on a Saturday night at a party with 30 or 40 people, with music stopped and us on a dance floor. It was given a great amount of thought to catch me off guard. I say off guard in a positive way.
You mean she proposed to you?
No. The acceptance, because she always said that when the time is right, she would accept. So she did it so that everyone would know.
She accepted the
Correct.
proposal. And you decided to rent a home together. And you gave her certain trinkets. You gave her a diamond necklace or something.
Correct.
To solidify the moment. Well, you changed your mind.
I changed my mind.
Soon.
I woke up within a couple of days, and it took me about 2 weeks to get the courage up to say something to him, and I told him.
Real cases, real people. Judge Judy. Ronald Meckler claims ex-fiancée Catherine Virgin owes him for items he purchased for their townhome and for an airline ticket.
Ms. Virgin, you returned his gifts to him?
I returned his gifts to him and gave him the opportunity to take any items that he had at the townhouse with him, or I would pack them and ship them to him. And his response was, I don't care about them. For all I care, throw them in the garbage. And so I eventually disposed of them.
Now he wants them.
No, Judge, there were furnishings for the townhouse that were purchased solely for that particular townhouse. I have a house in Houston where I did not need any of the, quote, furnishings, bathroom things and kitchen utensils.
Tell me what items you're talking about, because you talk generally about personal items that you want, and you are also suing her for the cost of an airline ticket.
Correct.
You'll get to the airline ticket in a minute. Let's talk about the personal items that you say you want from the townhouse. Tell me what they are.
That we furnished a bathroom, a couple $100 worth of bathroom furnishings, some kitchen utensils.
Talk to me about bathroom utensils.
Okay.
Like what?
Ceramic glasses, cup holders, toothbrush holders, curtains, towels, normal bathroom furnishings.
And what else?
Kitchen utensils.
Tell me.
High-quality spatulas, cooking utensils of that nature.
Is that what we're talking about here?
Yes.
Now tell me about the airline ticket.
After her acceptance, I went back to Houston, and we had conversations daily regarding when I was going to visit and when I was going to go there to look for employment, et cetera, et cetera. Because the price of airfares was increasing, if I bought the ticket well in advance, I would get a good fare. I purchased the ticket non-refundable, non-exchangeable on the 1st of November. And when she turned and canceled everything on my birthday, on November 12th, she said, well, you can do whatever you want with the ticket. And I there was no use for it at that point.
Let me ask you these questions, Ms. Virgin. Is it true that you purchased for the townhouse cups, cup holders, soap dishes, some towels for the bathroom?
He purchased. I already had those items in my house.
So he purchased them.
Correct.
Where are they?
He told me to dispose of them, and I did. I got rid of them.
You wouldn't get rid of brand new stuff.
Yeah,
What did
I
you do with them?
I didn't want them. They weren't my colors, so why would I want to keep them in my house?
So what did you do with them?
I work in a warehouse. I'm an accountant, and so I boxed them up and took them into the office and put them out on one of the lunchroom tables and told the guys it was free stuff to help themselves.
And what about the kitchen stuff?
That too. He never said a word to me that he wanted these items back. He told me to throw them out, so I got rid of them.
Yes.
Judge, I tried through emails to tell her that we needed to talk. She refused to speak with me. She absolutely refused to speak with me.
Mr. Meckler.
Yes, ma'am.
I want you to forget about the airline ticket. I'm going to tell you why.
Okay.
Things happen, situations change. If Miss Virgin changed her mind with regard to the marriage, I assume that you are not attributing to her any malice. That she lured you down there, just as you had lured her to Houston the year before to look for a job and it didn't work out. I would assume you don't think that this lady was getting even with you by saying, well, I'm going to lure him down here, make him spend a whole bunch of money on spatulas and then break his heart. That didn't happen, Mr. Meckler. So that if situation doesn't work out, she's not responsible for your airline ticket. Did you pay for her airline tickets when she came to Houston and it didn't work out for her to go back to Portland?
She drove.
Did you pay for her gas?
No.
Did you make that trip in one day?
No, took 5 days going down.
And I assume you didn't sleep in the car?
No.
Did you pay for her motel bills, her food bills, or anything else?
No.
Why? Because it didn't work out.
That's correct.
Neither did this.
Okay.
Oh, he's such an affable guy. What'd you let him go for?
No, but subsequently, I can be worse. But subsequently, I gave her an opportunity to settle for some of the things. There were also dishes that she still has or uses, or I assume that she does. And she said, well, I owe you for the dishes, which are all on the same receipt.
Are you using the dishes?
Yes. And that was the only item that I did go to the store with him that night to get because I had left mine back in Houston.
Were the dishes expensive?
No, they were $50 for a 4-place setting.
Just 4-place setting you got? Didn't expect to have much company.
No.
Mr. Meckler, do you ever remember saying to her, I don't want that stuff, just get rid of it?
I never said get rid of it. What I said was that I had no need for it back in Houston. I said it was specifically for this townhouse and for us.
So you said to her, I have no need for it back in Houston.
That's correct.
If you had no need for it back in Houston, it means that you didn't want to take the items with you. That could be interpreted as meaning, I don't want the stuff. But she does not have to reimburse you for it because there is no theory in the law that suggests to me that you have a valid claim. And unless, sir, you can establish to my satisfaction, which I don't believe that you can, that she perpetrated a fraud upon you by agreeing to marry you, and one of the things that she wanted by perpetrating this fraud was for you to furnish up her bathroom with some bathroom towels, that's a far stretch. I think it just didn't work out. I think that Miss Virgin probably behaved appropriately. You gave her some expensive jewelry.
Which she, in turn, was supposed to return. And 3.5 weeks later, she sent me an email saying, in case, and let me read this to you, just so you understand. Quote, thank you for the new watch. I love it. In case you hadn't figured it out, I exchanged the necklace for something more functional for myself. She told me on the 12th of November that she was going to return it that week.
I thought you did return the jewelry.
I did return it, Your Honor.
I mean, return it to him, not return it to the store.
I returned it to the store, and what made me, and I was so angry.
Oh, there you go. Okay, go ahead.
We had exchanged some checks. He had made a payment on one of my bills for me, and he wrote me a check to help cover for the deposits on the townhouse, because it was obviously, it's a lot larger than I would need as a single person. And so Thanksgiving weekend, I went to the ATM machine to get some money so I could go buy some flowers to take to my host and hostess where I was going for Thanksgiving dinner, and my checking account was overdrawn because he had stopped payment on the check that he had given me. And when I found out he had stopped payment on that check, but yet he could cash mine, it made me mad, and I did something stupid. I went down to the jeweler and I exchanged it for a watch, thought about it over on the weekend. Monday morning, I took it back to the jeweler and said, I don't want this. Please credit Mr. Meckler's account. And they did so, and then I mailed him the receipt. I express mailed it along with a couple letters that he had sent me that I had never opened or read.
Is what you're saying, sir, you never got that?
She exchanged the pendant. No.
You never got a credit for anything?
Eventually, yes.
Fine. She was angry, but then she did the right thing. Listen, Mr. Meckler, what kind of work do you do, sir?
I'm a stockbroker.
You're trivializing something that was supposed to be a good thing, turned out to be a non-thing. The couple of $100 that you're talking about for some towels is not worth your time. I don't even know why you elected to sue her in the first place.
Judge, with going back to the pendant situation for a second, when she took the pendant, she was supposed to directly return it to the store for credit as it was. She, in turn, exchanged it and committed a fraud in getting other items for herself.
No, she didn't. A pendant is a gift, sir. It is not an engagement ring.
That's correct.
It is a gift. She did not have to return it at all. She was perfectly within her legal rights to keep that jewelry that you gave her. She didn't have to return it. It didn't work out, Mr. Meckler. Get over it. Case is dismissed, that's all.
Thanks.
Parties are excused. You may step out.
Former employees 34-year-old Kathy Light and 36-year-old Mark Light. Faye claims while managing her bed and breakfast, they stole money from her and wrecked her car. Kathy and Mark are countersuing for harassment and an assault.
Order. All rise. Yeah, this is case number 437 on the calendar in the matter of Haas versus Light. Parties have been sworn in, Judge. You may be seated. Folks, have a seat, please.
You are the owner of a bed and breakfast.
Yes,
According
ma'am.
to your complaint, you had hired the defendant to manage your operation when you were out of town. Your complaint is that Mrs. Light wrecked your car and additionally stole a substantial amount of money from you. Mrs. Light denies wrecking your car and, of course, to stealing any money from you, and in addition has countersued for harassment and an assault that took place while she was in your employ. So, Ms. Haas, when did the employment begin?
Well, Kathy came sometime, I was critically injured, and it was sometime in July, and Kathy came and said she needed a job, that she'd never been able to get one, and would I give her a chance? And she's never, to my knowledge, had any kind of job at all, so I said I would give her a chance. But I didn't check any of her records or anything.
That doesn't make you a very good business person.
No, it doesn't.
So she came to work for you in July of the year 2000?
Yes, ma'am.
And when did you leave?
Well, actually, I didn't leave till October, but the incident when she wrecked the car, the two cars in particular, were us on September 30th.
Tell me about that.
Well, I was over with my boyfriend, who's now my husband, and I was over at his house in Red Bud, Illinois, and I had asked Kathy to bring me some money over. She was on my checkbook, and I asked her to bring me over $800 that we needed some money for some improvements we were going to do. So we were sitting at this like little bar and restaurant, and she came over there and she was highly intoxicated, and they asked us to leave the bar. So we took her down to Randy's mother's house, and she asked us to leave too. So Randy took Kathy up to his place where she insisted upon driving. She took the truck, and Randy was going to show her how to get to the road. It was a country road. She had a girlfriend with her who was not intoxicated. She hit the Camaro from behind with the Mazda truck and then went back to St. Louis. So she damaged not only the Mazda, but the brand new Camaro, which I have saved all my life to get.
Okay. Did she continue in your employ after September 30th?
Yeah.
She did?
Yeah.
Until what date?
Probably about November 11th when I came back from Florida, when the guest staying there had complained that she was doing a lot of narcotics.
Don't tell me what the guest said unless you have guests there.
All right.
November 11th of 2000 is when she was terminated.
Right. I had called her on the phone and said there was a lot of complaints against her. So
the whole month of October
yeah, she was
and
there.
for part of November, even
Yes,
after this accident, when you knew she was drunk and created scenes in two places,
Right.
you continued her in your employ.
Yeah, because I felt sorry for her. She said she had cancer.
Ms. Haas.
Okay, I'm sorry.
You should be.
I wanted to keep her on because she needed a job. She told me she did.
All right, now tell me about the theft of money.
Well, she wrote like a lot of checks. I mean, she never would keep any records, and she wrote like $500 for food, but she never bought any food for the bed and breakfast guests. So then she wrote $500 for her boyfriend, Mark, to remove a tree limb, but it was never removed.
Well, I'm not going back to $500 for food. I will take a look at the paper that you have with regard to the removal of a tree limb.
Okay. Here's the tree limb is still there.
Well, this says payroll and tree service.
Kathy was not even there. I was paying her $10 an hour, but she was never there more than 20 hours a week.
Well, you know, Ms. Haas, who do you think is going to go over all these little receipts? You were paying her $10 an hour. She wasn't there for 40 hours. She only should have been paid for 20 hours.
She was supposed to send me her time record in Florida, but she never did.
Who were Randy and John?
There was friends of mine that I paid to have them drive the car up there, but Kathy seemed to have take a liking to John for some reason. I don't know.
Whatever. She's got a check here that's a memo for Randy and John.
Yeah, that's for Randy, my husband, and a friend of his.
She told me to cash the check and give them $1,000 to Randy and John to drive her vehicle up to Florida.
She did that.
Well, that's one of the things you gave me.
She did that.
What
but
about,
then there was that additional
just a second,
$500.
what about $500 in cash for a phone recorder?
She had asked me to purchase a phone recorder so she can record conversations as she's talking to people. And she had a limo that was being stored at some people's house, and when I quit, I didn't even worry about getting her phone recorder. I just went and paid for the limo, gassed it up, and brought it back.
That's not true, ma'am.
Is that when you quit?
Yes.
When did you quit?
She got fired.
I quit on November the 11th, 12th, something like that.
Well, this check was written on November the 5th. This is before you quit.
The check for $1,000, it was the day
I didn't ask
after.
for $1,000. I'm past the $1,000 already.
Yeah, the check was wrote for $1,000. I quit the day after.
She got fired.
Just a second. Ms. Haas?
I'm sorry.
Don't speak out again.
Okay, I'm sorry.
Okay. You quit the day after you wrote out the check for $1,000?
Yes,
Fine.
I didn't like
it. You wrote out a check on November the 3rd, payroll and tree service, $400.
That was my payroll. And
What payroll for whom?
For working for her.
So you kept your own hours?
No, Miss Haas and I had made an agreement that I would work so many hours, but she had me running errands to lawyers and doctors, which made it consume more hours.
This is all a very loose way of doing business. One final check I'm going to ask you about. You have a check to mail packages and x-rays, $500. What's x-rays?
I had to go to all these hospitals that she was in and get all her medical records. I had to Federal Express it overnight to her.
Oh, is that true?
It's $20. They were $20.
Show me a bill.
I don't have a bill for the x-rays.
Well, how am I supposed to have a bill, madam?
Well, maybe she
This
does.
was on October. You're supposed to keep close eye.
I was in Miami Beach, Florida.
I don't care whether you
I know, but I was
don't care
critically
whether
injured. I
you
was
were
in
in
the
Panama. Listen to me.
I was in the hospital.
Listen to me. Then you don't give a stranger.
I know
a
that.
stranger who you know has an alcohol abuse problem.
I know that, madam.
You don't give somebody who you hire off the street access to your checking account.
I know that.
Right? Sign them on and have no set salary for them and say they work by the hour.
It was $10
She
an
said,
hour.
well, you expect me to ask her on the 19th of October how many hours did you work?
I don't know. I was in
Well,
the
I don't know either.
I was in the hospital at the time.
On October 19th?
I was trusting her.
Well, then how do you expect me to deal with that? How do you expect
don't
any
know.
court to deal with that? I don't know either.
I mean, the car...
Let's get to the accident, because that's the only thing that may have an objective facts
All right,
that I
well,
can deal with.
He was a witness for the accident. Randy, can you come up here? This is my husband. Tell her what happened.
Okay.
Well, we called her from the bed and breakfast to have her bring us over $800 to Redbud. And she was highly intoxicated. And I tried 3 or 4 times, to let her stay at my house. She wouldn't do it. She refused. So I took her out to the end of the road. She ran to the back of the car.
Had you been drinking?
Who, me?
That's exactly who I'm talking to, sir. Had you been drinking?
Yes, ma'am.
Right. What part of the day or night did this happen, sir?
It's probably about 8 at night.
And when had you started to drink that day?
Not at all.
Miss Haas? Miss Haas?
Okay, sorry.
Believe me.
Okay.
I know my business.
All right.
Watching this will be like looking into a Ouija board.
Real cases, real people. Judge Judy. Faye Haas says former employees Kathy Light and Mark Light stole money from her business and wrecked her car. Kathy and Mark deny the charges and say Faye assaulted Kathy with a plastic baseball bat.
What time had you started drinking that day, sir?
Probably 6:37
And where were you drinking, sir?
at a bar.
And what time had you arrived at the bar?
I wouldn't.
What do you mean you wouldn't know? What time had you arrived at the bar that day, sir?
Probably 6:37
From where?
from...
I don't know. I don't know. He doesn't remember.
Miss Haas, I'm not going to take any information
All right,
from him.
all right.
Forget it. You blew it. You
I'm
understood
sorry.
where I was coming
But
from.
he doesn't know what time it was.
He doesn't know what time it was because he was drunk.
No, he
Sit
wasn't.
down.
No, he wasn't drunk.
Oh, I have to assume that, because if he can't remember where he was on a day when two cars collided.
I don't believe you. We were waiting for...
I don't believe you that he doesn't remember where he was.
All right.
If he doesn't remember where he was on this fateful day, then I have to rely on her statement
He was with
that
me.
he was drunk as a skunk. Now, she may have been. That means you got two drunk people driving in your two cars, one a Camaro and one a truck. He was drinking and she was drinking, if I believe you. Although I have a little bit of a problem with that, because unless there's something wrong with you, you would not allow someone who is as drunk as you claim she was, that required her to be ejected from the bar, ejected from her mother's house, and yet you would still leave her in charge of your business, giving her total access to your checking account, relying on what she did with money, relying on what she did with guests, somebody who was clearly a danger, according to you. I have a problem with that, Miss Haas.
I'm sorry, I'm wrong. You're right. It was stupid.
All right, Ms. Lick, tell me what happened with the car.
She had called and they had asked for money, and I had a friend of mine, Jesse, ride over with me. Well, when I got over there, she buys Jesse and I one beer. She takes me across the street to a flower shop, buys me a bouquet of flowers, and then she insists on going and unloading the truck. So we went to Randy's house and we unloaded the car. As far as the car, there was no accident. I get home, and I get this phone call from Miss Haas saying I wrecked her car. Well, them two are both drunk, so I just basically blew it off.
But after this car incident...
I continued to work for her.
You continued to work for her?
Yes.
Okay. Now let's get to your counterclaim. Go ahead.
I quit working for Miss Haas because she would call me on the phone and cut me down and say I'm dyslexic and this and that, and my nerves couldn't handle it no more. So I call her on the phone in Florida and tell her I quit. 3 weeks after I quit, she's accusing me of all these things. She's trying to fire me after I quit.
So let me hear about this harassment.
She has been calling, my son and I have pagers. She has been calling our pagers. She calls my son and tells him that I'm a dope dealer and that she's going to have to take him to baseball games because I'm going to be in a federal penitentiary, because she's going to see to it that I go to a federal penitentiary. I went and got a restraining order against her.
Let me see it.
Not true.
Kathy, shame on you. Shame on you.
Ms. Haas, you consented to the entry of a restraining order against you by your counsel. Is that right?
I was in the hospital and I could not go. Yes, ma'am. Yes.
The answer is yes. If you're in the hospital and you can't go, then your attorney asks for postponement.
I don't know what he did, ma'am.
Of course you do.
No, I don't. I really don't, Judge Judy.
He consented to this entry.
Well, he went there supposedly to postpone it.
December 20th of the year 2000. Yeah. He consented to the entry of an order of protection.
Well, I'm sorry about that, but I've never laid a hand on Kathy. She wanted me to adopt her.
And the order of protection specifically says you are not to abuse, threaten, molest, stalk, disturb, and no telephone calls, and shall not communicate with her in any way whatsoever.
Right.
Now, you came back from Florida on November 11th.
Right.
And according to you, you told me that you were in the hospital in Florida.
I was in the hospital in Florida, in Jackson Memorial Hospital and Mount Sinai.
Well, what'd you go to Florida for?
To get another opinion on my arm that was going to be amputated.
And when were you admitted to the hospital? When you returned in November?
2 days later, a week later, I was admitted to the hospital for
So that would be the 18th of November.
Right.
Is that correct?
That's correct.
And how long were you hospitalized?
2 days.
Were you re-hospitalized at any time after November? Believe me, I will check.
No, no.
So that you were not in the hospital at the time that your attorney entered a consent order. You just said you told him to go there and not do anything, put it over because you were in the hospital.
I could not leave the house. I was not allowed to.
Just a second. So that you were not hospitalized as you originally said.
But I had a nurse at home and I could not leave the house.
All right. It's a month later. Month after your surgery. People recover from open heart surgery faster. After this order of protection was issued, were there any other harassing phone calls?
Yes, I have them on tape here.
Let me hear.
Okay.
Hey, Mark, it's Frank. Guess what? Lisa and Paul are going to testify in court. What kind of guy lives with his brother's wife? Low-life Hoosier.
I said that.
Yeah, Mark, it's Faye. I got the restraining order from the sheriff. We never had any intention of hurting Kathy, but I am going to file criminal charges against you, Mark Light, and Kathy Light for dealing methamphetamine, marijuana, prescription drugs, not only out of my home, but my place of business. We're going to bring up Kathy's past arrest record. So when you show up in court, you better spend about 10 grand to have a very, very good attorney. We are not threatening you. We want nothing to do with people like you, Mark and Kathy Leach. Have a nice evening. Yeah, Mark is saying, have Kathy send me the money for the 2 cars she wrecked when she was drunk on her. I mean, that night that she dealt methamphetamines out of my house. End of messages.
I also have tape here of her calling and leaving messages. I will go ahead and play this for you.
How do you think you and Kathy for dealing marijuana out of your house? This sheriff will be down there. Either pay me back or you go to jail. Yeah, now tell your girlfriend Kathy Leach, also known as a major drug addict, to bring back the gift certificates to her and all the food certificates she sold. What a woman.
Okay.
I said that. I did. I was
that letter?
I was frustrated.
You were frustrated. You were breaking the law.
Okay. What? I'm sorry about that.
Or
I'm sorry
you were
about the
breaking the
attorney.
law?
I'm sorry about the attorney I got to go down there.
Well, that's not my problem.
I
Adam.
know that,
That's your
but-
problem. You were clearly aware that you were served with a final order of protection. Final order of protection said absolutely no contact, and specifically no telephone calls.
She had all my records at her house. How was I supposed to get them? Go down to her house? Her neighbor's very dangerous.
I don't quite frankly care what precipitated it. All I care about is there was an order that you were made aware of by service, because you indicate on this that you
But I
had...
asked her why she was
No,
doing
you
that
may
to me.
not ask a question.
I was asking you why she would do that to
You
me.
don't
when I-
ask me any questions. I'm telling you.
All
You
right.
were served with an order. You were on notice. You continued to harass her. And in addition, you violated the order.
And as far as her abusing me, she would hit me with plastic bats and wooden and metal canes.
When did she do that?
When I was working for her.
Why didn't you leave?
Mark had made a joke to her about telling her that she had to stop hitting me and leaving bruises because she would have to pay $50 for each bruise and $100 for blood, and we was just joking about that. But that was to get her to stop hitting on me.
so insane. Just so nuts.
Listen to me.
I'd leave too if somebody did that.
This is certainly not a think tank here. However, if I'm working for somebody and they even think about hitting me, I'm gone.
I know, but...
I know. They don't make a game of it.
do
Every
it.
time she hits you and leaves a bruise, you get $50, $100 for drawing blood. I mean, that's the dumbest thing I ever heard. Your claim against her is dismissed. You have no proof. And I'm not satisfied with hubby's proof that he wasn't responsible for this accident. You have no tangible proof that she stole anything from you. You do have proof, however, that she continued, despite the issuance of this protective order, to continue to call you, which is in violation of the protective order. And on the counterclaim, I am awarding you $500. That's all.
Parties are excused. You may step out.
8-year-old tour manager Mark Gilbert is suing his former landlord, 80-year-old Lillian von Lossberg, for destroying his property after she evicted him.
Order. All rise. Yes, case number 412 on the calendar in the matter of Gilbert versus von Lossberg. Parties have been sworn in, Judge. You may be seated. Folks, have a seat, please.
Mr. Gilbert, you were a tenant of the defendants for approximately a year and a half. Is that right?
That's correct, Your Honor.
Did you have a lease?
I believe it was a month-to-month lease, yes, Your Honor.
You did not have a long-term lease. You were there month to month.
That's correct.
Your claim is that the defendant evicted you,
That's correct.
and in addition to evicting you, she destroyed some of your property, and she kept some of your security deposit. You also want her to pay for storage of your stuff, moving costs. So let's start with this. You did not have a lease.
That's correct.
You claim she evicted you.
Yes, ma'am.
She says that you voluntarily left. Let's get to that.
Item A that I have in evidence is a 30-day notice to quit that was taped to my door the day August 2nd, which is the day that most of this occurred.
You want to tell me briefly what happened that day?
I enjoy very much working in my yard. On this morning, I had finished the night before, just coming home after 3 months of work. I'm home for only 7 or 8 days, and I'm gone another 3 months. Did the gardening, and a stranger walked into the front yard. I picked up my hose that was watering some plants, and I asked him what he was doing. I went outside. I was inside when I asked him this. I went outside and asked him what he was doing, and was told to my face that he was my new gardener and that he was Mrs. Vaughn's nephew. And I explained that I'd done most of the yard work and that all he really needed to do today was cut the yard. He turned around and ran next door, immediately followed by Mrs. Vaughn and a good number of her other family members. And I explained that these plants were mine and I could do with as I wish. She immediately turned around and took one of the plants and stripped it right down to its bare stalks. That picture I have here, this is a former palm tree that Mrs. Vaughn at the time took and stripped of its branches. At that point, I was so angry, Your Honor, the only thing that I could think to do was to go inside the house and call the police, and that's what I did.
Was that the first time you had disputes with the defendant?
No, actually, Your Honor, I ordered Media One to install the cable service and a phone service and combine them with a DSL line into my house here. And immediately the next day, Mrs. Vaughn informed me that she did not like Media One as a company and did not approve of them coming to install this on her house without my obtaining her permission.
Mr. Gilbert, let me stop you for a moment, please, sir. You know what it is to be a month-to-month tenant. Month-to-month tenant means that she can give you this 30-day notice to leave, and she doesn't have to give you any reason.
That's correct, Your Honor.
So you are not entitled to moving costs, storage costs of your stuff, any other damages. You're not entitled to that. Is her house immediately next door to yours?
It was, yes.
Well, where you used to live. It
Yes.
still is. It didn't
Yes.
float away in the
Yes.
rain. It's still there. All right. She doesn't want somebody living next to her who calls the police on her because she destroys a tree. Right? Once, by the way, you put this tree in the ground, this tree does not become yours.
If I pay rent on a property that I maintain until I leave that property, is the property not mine, Your Honor?
No, the property is not yours, sir. The property always is hers. And while it's not nice to do this to a tree, I can understand why this lady didn't want you living next door after the police were called even once, even though you may have felt that you had cause because she stripped the branches of this tree. So she's entitled to evict you, so you're not entitled to those damages. However, you also have a claim, sir, for withholding your security deposit. How much security deposit did she withhold?
She withheld $779.80, Your Honor.
Is that correct, Ms. Vaughn? You admit that you withheld some security deposit, is that right?
I have a hearing problem.
Well, I can't shout any louder.
I'm sorry.
I
heard you say something about a...
Did you withhold security deposit?
He had an $1,100 security deposit. When he moved out, I spent a portion of that to clean the apartment because when he left another person in that house that was sleeping in the living room. When I entered the place, after he left, the sink was littered with beer cans, whiskey bottles, and whatever.
Show
and
me
I
pictures.
spent money for cleaning that.
Show me pictures.
I didn't take a picture, I'm
You
sorry.
got a problem.
But I refunded him $300 and some out of the security deposit.
You have to show me, Miss Vaughn, do you hear me carefully? You have to show me exactly what you spent.
I think I do have the receipts here, Your Honor.
Let me see. You can show it.
He'll have to assist me.
Your Honor, I can maybe save you some time. I have a copy of both the receipt
Let me
and
see.
We had
the
the
deposit
receipt.
refund form she sent me.
I have to excuse you, but you're 80 years old.
Your Honor, I claim that receipt to be a company that doesn't exist.
Oh, right there.
That the
Right there.
handwriting on it matches the form.
Just a second, just a second, just a second.
Okay.
Plus the damages on the outside of the house.
What's the name of the company that repaired the doorbell, painted and cleaned, and put in new locks?
I don't know what the name of the company is.
Now, what's the name of the company?
It doesn't have a heading on it. You don't have it on there? Otherwise, my...
Miss Vaughn,
Yes.
either I don't believe that you did all this stuff, or I believe that somebody else did it for you, like a family member. You are not entitled to put in new locks. you're entitled to clean if you show me that the place was filthy. That was $70. You have two different bills here for painting, one for $350 and one for $380. But nowhere does it tell me who did the painting.
Yes, Your Honor, I understand that.
There's no proof.
That's right.
And you have no pictures to show me of what this place looked like.
No, I didn't think of
Who are you?
I'm her witness, her daughter.
Come on. Do you live with your mother?
No. I live on one side of my mother, and he lived on the other side of my mother. And my daughter lived 2 doors down.
I don't care where everybody lived. Did you go into the house on the day he left?
Yes.
Did you take pictures of the house on the day he left?
My daughter did. I didn't.
Fine. Where are the pictures?
She has since moved to Pomona, and
that's not my problem. You don't have the pictures.
Before he moved, she told me that she
I don't care what. Listen to me. Listen to me.
All right. I was
You
told,
can't tell me what anybody else told you. You can tell me. Pay careful attention. Listen. I want you to start receiving. Did you see anything else? Look at me. Did you see?
Yes.
What else did you see?
He had put up some shelves in the utility porch in the back.
Yes.
That weren't there before he rented.
Yes.
And instead of washing the walls or to make things right, he either spot painted or spot cleaned, because when you look down the angle of the wall, you could see splotches where he had either spot painted or spot cleaned.
Sounds to me as if he was a very good tenant.
And
listen to me. You want to bring paid bills from somebody that's reputable, that puts their name on a receipt. You can do that. This is nothing. Absolutely nothing.
Can I say something?
Sure.
When I was served with a subpoena to appear in court, I did not, he said he was suing me for $3,000 with absolutely no reason of what his intentions were of collecting this money. I could have gotten the company, the man that did the work, to come in today had I known how to defend myself. But I had absolutely no idea of what this man is suing me for.
Okay. He was suing you for $3,000. Initially, he's not going to get $3,000, and I told him that. But he is going to get his security deposit back.
No, he got it all back.
No, he didn't, and he's going to get it back because there is no basis for you to withhold the vast majority of his security deposit.
Can I show these to the court as part of the damages?
Let me see. I asked you if you had pictures. You said no. What are you showing me?
That's what he ordered Media One without my permission, and he drilled holes in the floor, the side of the wall, and the building as it stands today needs to be painted and repaired.
Oh, goodness gracious me, madam. Looks to me as if he maintained your house in
And I have the name.
Quiet and listen. It looks to me as if he maintained your home in pristine condition. Anybody that maintains the outside of this house the way he did not maintain the inside like a pig pen. What?
Your Honor, he was running a business outside of a residential home, and that's why I called Media One, and I asked him why he had run all the wires into the house, drilled through the floor, drilled through the walls, as the pictures will indicate.
Show me where you paid to have the holes refilled.
They haven't.
No,
Good.
I'm going to have a lawsuit. I intend to sue him for that. This will follow up.
Good. Judgment for the plaintiff in the amount of $779, which is the amount of the security that was withheld from you, sir. She had no right to withhold your money. You are getting your security deposit back. Goodbye.
Thank you, Your Honor.
Parties are excused. You may step out.
As long as he had his way, he was a good tenant, but don't cross him because then immediately he thought that I was his enemy.
Never live next door to your landlady, ever.
And now the next case.
All parties on Oswego versus Bell. Step forward, please.
38-year-old registered nurse Yvette Oswego is suing 38-year-old receptionist Lisa Bell for burning her scalp during the process of relaxing her hair.
Miss Oswego?
Yes, ma'am.
According to your complaint, about a year ago, the defendant did a hair procedure on you, and according to you, burned your scalp and your hair fell out.
Yes, ma'am.
And according to what I read in your complaint, this procedure was done in the defendant's kitchen.
In her mother's kitchen.
Why?
That was the place that she advised me to come to have my hair done.
What were you doing to your hair?
She was relaxing, putting a relaxer in my hair.
Your Honor, that was not...
How did you find her?
I met the defendant through her sister. Miss Pete told me that her sister was a licensed beautician and that she had graduated from beauty school and was looking to build her clientele up.
So you went to her mother's house and she started to put this product on your head?
Yes, ma'am.
And what happened when she put the product on your head?
It began to burn.
No, you're...
When she got ready to wash the chemical out, she took me into the kitchen because I told her that it was burning rather badly. But the sink was full of dishes, and so she had to clean the sink out, and she had to get the faucet to work. And she made the comment to her mother, "That's why I don't like to do hair over here, because your faucet is messed up." So my scalp felt like it was on fire. I mean, I was literally standing on one leg saying, "Please hurry."
Do you think it was very smart to go to somebody's house to have your hair relaxed?
Ma'am, in the African American community, sometimes people have shops set up in their home.
Yes, but then it looks like a beauty shop. It doesn't look like a kitchen with dishes in the sink.
Well, she had the chemical on my hair by that time when I realized that she was going to have to go into the kitchen.
Okay, what happened to your hair after this process was done?
I have pictures for ma'am.
My hair, please.
There's a before and after.
Now, this happened a year ago. What took you so long?
I tried contacting Miss Bell on several occasions, and she agreed. She said, "Well, my instructor told me she don't see how you sit in the chair if I was burning you that bad." I said, "Well, if you recall correctly, I told you you were burning me and asked you to wash it out."
So what did you want her to do?
I wanted her to assist in paying for treatment for my hair.
Did you have treatments?
Yes, ma'am.
How much were the treatments?
I had several treatments. This gentleman, my hairstylist here, did my hair.
Afterwards?
Right.
Step up, please. Tell me your name.
Henry Jerome Clay.
Can you describe what you saw when you saw her?
When Miss Oswego came to me, she made an appointment to get a relaxer. But after consulting with her and examining her scalp and everything, I told her there was no way I could do a relaxer.
She wanted another relaxer?
Well, new growth had started growing out, and black women, they mostly want their hair to look good, you know, and she wanted to try and get the situation better. But my suggestion to her was get some treatments first. Start taking care of her scalp, get her scalp back healthy, and then cut all her hair off and start all over again.
So what kind of treatments did you provide for her?
I gave her a deep penetrating conditioner for her scalp and her hair as well. The hair that she previously had on there during the relaxer procedure, it was breaking off because it had burned all the way through the cortex of her hair.
Thank you.
You're welcome.
Now, Miss Bell, I have a couple of questions for you. You ready?
Yes.
At the time that you took care of the plaintiff, were you a licensed beautician?
No, I was not.
So why do you think that you were allowed to work on strangers?
Well, I didn't think that I had right to, but she knew that I was not licensed. She knew that I had just graduated from beautician school.
You were told that she had graduated from beautician school, correct?
Yes, ma'am.
But you had not yet passed the licensing exam.
Correct.
Well, a lay person, that means a person who's not in the business, wouldn't know that you had to pass a licensing exam before you could work on somebody. She was told that you had graduate of beautician school and therefore assumed that you could work on her. Now, you're not allowed to work on her, right?
Right.
You must be her sister?
Yes.
I know that you want to tell me something, so I'm going to let you tell me what you want to tell me. Step up here. What? You're Miss P.
Yes, I am. When I met Yvette in graduate school, I had specifically told her that my sister had just graduated from school. She had not passed her, she had not even taken her licensure exam.
You told her that?
Yes, I did.
Did she tell you that?
No, ma'am.
Oh, I don't think so. Sit down. No. You don't say that to somebody. Try my sister. She's graduated from school, but she hasn't even taken her test yet. She's not licensed yet.
Yvette has specifically told me that her niece used to do her hair.
You want to let your sister-in-law, your sister, your mother give you a home perm. That's one thing. I once gave a home perm to my best friend. It's amazing that we're still best friends 50 years later. She could have used a relaxer. But we were only 12, you see, at the time. But you don't work on strangers. Did you ever get your license?
No, I didn't go back to get my license.
Why not?
I took my test, but I did not. I passed my practical, but I
you failed the other part.
Right.
So you failed the test.
The written exam.
You failed the test.
Yes.
You were never licensed.
Yes.
Well, that's why you don't work on somebody. Miss Bell, what kind of work are you doing now, madam?
Oh, I'm a receptionist.
Good. Good. You had no right to work on her. You placed her at risk, and you are responsible for all of the damage that you caused. The plaintiff is suing for $3,000. Is that right?
Ma'am. Yes, ma'am.
Judgment for the plaintiff in the amount of the request, $3,000. Thank you.
Parties are excused. You may step down.
Rachel Cale and her husband, 23-year-old electrician Brian Cale, say former friend, 28-year-old Aaron Whitten, borrowed their car and returned it damaged.
Order. All rise. Yeah, this is case number 301 on the calendar in the matter of Cale versus Whitten. Parties have been sworn in, Judge. You may be seated. Ma'am, have a seat, please.
According to the complaint that I've read, you loaned the defendant a car because he was in dire straits, and you said he could borrow yours until he got one that was supposed to be forthcoming very soon. Is that right?
For 2 weeks, we told him he could borrow a vehicle.
And he borrowed your car for 2 weeks. He kept it a lot longer than 2 weeks. By the time you got it back, it was pretty well trashed.
Mm-hmm. Correct.
So you are suing him for $5,000, a little high for the kind of car that you loaned to him. The car was a 12-year-old car?
Correct.
Okay. So were they very nice to you to lend you the car?
Yes, they were.
And why didn't you take care of it?
I did take care of the car, Your Honor. I did extensive.
Let's start with the windshield. Windshield was broken while it was in your custody.
Yes, ma'am.
Did you fix it?
No, ma'am, I could not get it fixed.
Then you didn't take good care of it.
Ma'am, the extensive amount of what happened was not in my control.
I don't care it was in your control. The car was in your control.
The car was in my control.
So then why didn't you fix the windshield?
Because I was not working at the time. What
so
happened
what you're
was
saying to me, it was your responsibility, but you didn't have the money.
Ma'am, there was 7 days notice. I was getting a threatening call from the plaintiff, the lady, had given me a call saying to me, demanding that I have to come up with $300 within 4 days.
How long did you keep the car?
I had the car for 2 months. The car sat for a month in my driveway because it had a broken windshield, Your Honor.
Why didn't you return the car after 2 weeks?
I don't know.
Why
you are misled, ma'am. The correct.
Did you call for the car?
Many times, and he was saying that he was going to be getting another vehicle. He had purchased it. He should have it in a few days.
Don't speak.
And we called back. Do you have the vehicle? No, I don't. That deal fell through. I just don't have that. But I'm getting another car, and I'm buying a motor separately, and we're going to be putting it all together, and then you can have your car. We still didn't hear about it. Then we tried continually calling and calling and calling and calling, and he wouldn't answer the phone. And then we finally, one evening when we did get a hold of him, we said, we will be there tomorrow morning. And he had called us early that morning, oh, the windshield's been smashed. Okay, so what are you going to do about it?
No.
I'll tell you just a second.
We gave him adequate time from when the windshield was smashed, which was roughly the beginning of September.
When had you given him the car?
We had given him the car around the June 20th of 2000. So it's longer than the 2 months that he's saying. That's over 3 months. We picked up the car. We had to go pick up the vehicle on September 25th, on a Monday, after I had to pay for the vehicle to be repaired, as well as we were also threatened by the defendant, stating that if we show up on the property, that his girlfriend is a police officer and that they will have friends from Dearborn come and arrest us.
That is not correct, Your Honor.
What are those tapes?
This is the tape showing that he did say that they would have us arrested.
What's the other tape?
And this is the tape of some of the damage done to the vehicle.
That I'd like to see.
Your Honor, may I say something?
In time.
Yes, ma'am.
This is me trying to get into the lock. He broke the lock on the car. This is us trying to start the car and park, which he damaged the vehicle. No longer starts and park. Here you go. We tried it a couple of times. It doesn't even turn over. Nothing happens. When we took it to the Ford dealership, then you'd broken the neutral safety switch with the drive shaft. And then when we go to start it in neutral, that the vehicle stalls as soon as we start it, if you can get it started. You can also see we had a Ford radio in the vehicle that was given to us from a friend, and I have a statement from her regarding that they had given us a radio because the vehicle...
Was the radio taken out when you got it back?
Yes. There was no radio in it. He'd also broken the seat to the chair. As you notice, the other chair's reclined, and this chair here is when you sit down in it, and when you lean back at all, it goes all the way back to the back of the seat. This is where the radio was located at prior to when Aaron had stolen it, as well as he also stole other minor things that were in the trunk of the vehicle at the time.
Plus the windshield.
Yes, plus the windshield.
You have the estimates
He's also
of the
done damage. Yes, I've got
Can I
damage
see it,
to
please?
the engine that he's also done. The vehicle, he drove the vehicle with no oil in it and burned the engine out. He blew out 2 tires on the vehicle. They're worn to the steel belts.
Just a second. You didn't take pictures of the tires.
Because we can't get I can't get underneath the car. I'm 8.5 months pregnant. I won't fit, and neither would my husband. But I have estimates from the Ford dealership and things showing that.
Did the car have 2 flat tires when you picked it up?
No, but you can see the steel. When you wear your tires down to the steel belts in your tires.
Let me see the estimates without the tires. Mr. Whitten.
Yes, ma'am.
You picked up this car sometime the latter part of June of
Yes, ma'am.
2000. Is that right?
Yes, ma'am.
And you picked up this car because you needed it for work?
Technically, I picked the car up from the defendant's sister's house, drove it to his parents' house, parked the car.
His sister was living at his parents' house, so she couldn't have
Just
lived
answer my
anywhere else.
question.
Yes, ma'am.
You wanted to borrow this car, I said, because you needed it for work. Is that right or wrong?
Correct.
Good. Just answer my question.
Yes, ma'am. I'm sorry.
What kind of work do you do?
I'm a state certified mechanic, ASC certified, and I was in the roofing union doing sheet metal.
And did you work? Were you employed in the month of June?
Yes, ma'am.
Were you employed in the month of July?
Half of July, I had injured my knee, and I was not able to work.
Until the injury, you went to work?
Yes, ma'am.
So you drove this car for approximately 1 month?
Yes, ma'am.
Perfect. It's scary that you read my mind. Do you know that?
Known you a long time.
When they just fall all over themselves, it's just such a pleasure. Even the smart Alex, you know? It's just such a pleasure for me.
Your Honor?
Don't speak.
Okay.
You borrowed somebody's car, you drove it for at least a month, you drove it every day to work until you hurt your knee, and you returned it to them in a condition that is completely different from the way you got it. And then you say,
Your Honor,
it's not my fault.
May I please tell my side of the story now?
Yeah, sure.
Thank you. I was sitting with my witness as a police officer, my fiance, on their couch watching a movie. If you want to know the correct movie, it was American
I don't
Pie.
give a rat's behind what you were watching.
Judge Judy continues in a moment.
Listen to me.
I have
Mr.
told
Whitten,
them,
Mr. Whitten,
Your
just
Honor.
listen to me. Don't try to shout over me. You can't do that.
And later today,
I heard a clink noise and looked down, and the explosion went off. Boom. Huge explosion.
real cases, real people. Judge Judy. Rachel and Brian Cale say former friend Aaron Whitten owes them for car repairs.
Go ahead.
Rachel, the plaintiff, pardon me, I'm sorry, had said, Aaron, you can use the car as long as you want.
That was real nice.
Yes, it was. The reason why I think it was being real nice is because I've gone over there extensive amount of times and helped them.
Don't go into what's in their mind.
I received the car with damages. When I first met the plaintiff, me and him went hunting.
I don't care about. Listen to me.
It falls in for the point of for your material. The neutral starting, Mr. Cale had to pull his shifter down to start it every time. That was a lie.
That's not true.
The stereo was stolen from their house. It was in a Kenwood or an Alpine, I cannot remember correctly, was stolen. Plus with some
Just a
other
second.
stuff.
Is what you're telling me, when you got the car, It did not have anything in that hole.
No, ma'am, nothing.
No, nothing was in the hole but the radio, the letters from the lady who had given us the radio to put in there, because the radio was stolen prior, the one that we had in there.
The radio is sitting in their garage on a chair.
So he is absolutely right. There was no radio in the car.
That's what no, it was in the trunk of the vehicle, and he stole it out of the vehicle when he had our vehicle.
Listen to me. You have no loss for the radio. You didn't buy it. Somebody gave it to you.
Yeah, but if we have to replace it, we have to pay over $400 for that radio.
I'm not sure.
Well, if you look at the estimate from it.
That's not what I'm not sure about. I'm not sure that you left the radio in the car and that he stole it. What's next, sir? So far you got off the hook for the radio.
Yes, ma'am. The charging light came on. When I picked up the vehicle, we had to jump start the vehicle. He also said that the battery light does stay on. The reason why the battery light stays on is because the voltage regulator unit was freezing inside the vehicle. Check engine light came on because it has a bad O2 sensor. It had an idle ignition sensor.
Why didn't you bring it back to them? Listen to me.
I have told them.
Mr. Whitten,
Your
just
Honor,
listen to me. Don't try to shout over me. You can't do that, sir.
No, Your Honor. I'm not trying to shout over you.
Good.
But what I am trying to tell, I am trying to tell you my side of the story.
You're almost ready to go. If you have a car that you borrow from somebody and it has all the trouble, sir, that you say this car had.
They know the troubles, Your Honor. They knew about it.
You're interrupting me and you're ticking me off. Pay careful attention to me, sir. Normal, reasonable person. And if your girlfriend is a police officer, she's heard the expression of reasonably prudent person, right?
Yes.
If they borrow a car from somebody and the car looks as if it's having real trouble, they return the car. They say, look, I drove it for a couple of days. I see it's got lights on, and I don't want to be responsible if anything goes wrong with it. So I'm giving it back to you, and I'll find some other way to get to my roofing jobs. They don't drive the car for a month and then say, the car had a lot wrong with it, therefore anything that happened to the car isn't my fault. That's what a reasonable person does. Okay. And if you did not act responsibly, you have to be responsible for the consequences of what you do.
Yes, ma'am.
Okay.
May I finish my... No. I have some other evidence. I mean, they got to describe their evidence. I should think I should.
No, there's no way that they're going to get $5,000 award from me.
They could even serve $400 for what the car is.
I am speaking.
So was I.
So were you?
I was rudely interrupted twice.
I never rudely interrupt. I start to talk. It's my courtroom. You have to stop. That's the way the rules are in a courtroom.
Doesn't the called rights too?
Yeah, you have whatever rights I give them. Judgment for the plaintiff in the amount of $1,500.
As far as I excuse, you may step out.
They were lying. They knew the problems of the car. They tried getting some outrageous thing. This is a classic case of somebody trying to get something for nothing.
At least now everyone gets to see what Aaron looks like, and now they have to know never to lend him anything because they won't get it back in the shape that they lent it to him in.
And now the next case.
All parties on Buersdorf versus Gagnon. Step forward, please.
33-year-old wildlife technician Frederick Buersdorf is suing former friend, 37-year-old landscaper Dave Gagnon, for throwing a spray paint can into a bonfire. Frederick says the can exploded, causing third-degree burns.
You were at a bonfire attended by a lot of people. Is your claim that the defendant, these are my words, the defendant, while acting like a complete fool, threw a paint can into the bonfire, which caused you to be severely burned?
That's correct.
You want him to pay for your medical bills and a substantial amount for pain and suffering.
That's correct.
When did this incident occur?
October 7th, approximately 6:30 in the afternoon.
Where was the bonfire?
At my brother's house. He had just recently moved into a place.
What time did you arrive at your brother's house?
About 6 o'clock.
6 p.m.?
That's correct.
And what time was the unfortunate event which caused you to be burned?
Shortly after. I wasn't even there, about a half hour.
So it was about 6:30?
That's correct.
Now, Mr. Gagnon, what time did you arrive there?
Approximately the same time, Your Honor.
6 o'clock?
Yeah.
Had you been drinking before?
Yeah.
How much?
Probably about a 6-pack of beer.
Judge Judy continues in a moment.
I vaguely remember it, Judge. At the time, I was pretty intoxicated.
So you really don't know what you did?
Real cases, real people. Judge Judy. Frederick Buersdorf says former friend Dave Gagnon owes for injuries he suffered when Dave threw a can of spray paint into a bonfire. Dave says he didn't do it.
Now, what prompted you to pick up this paint can?
I don't know. I seen it, and I put it in the fire earlier. And
how much earlier, sir?
About an hour or so earlier.
You said you arrived there at 6 o'clock. This incident happened at 6:30. So
Well, I'm not too sure about the time, because I really didn't get the, didn't look at a clock or nothing.
So you threw a paint can into the fire, and nobody was hurt, I assume, at that time?
No.
And it is your defense that you did not throw the paint can that caused his injury?
Correct.
Do you know who did?
No, I don't. There was a lot of people around the fire.
How many people?
Probably about 18 people.
Now, Mr. Brusdorf, tell me about the exact moment when this paint can exploded, and we're going to go through the events of what happened afterwards.
Okay. I recently got there, stood in front of the fire, I was talking to some people, conversing. I heard a clink noise and looked down, and the explosion went off. Boom! Huge explosion. Burnt my forearms, my right face, all of my fingers, my wrists. First, second, and third degree burns. I have pictures here, too.
I'd like to see the photographs. How long were you hospitalized?
I was in and out treatments, debridement, every day for 13 days.
How did you get to the hospital?
A friend of mine that was showing up had brought me to the hospital. I went right into the house and immediately started putting water on my face and arms for about 20 minutes or so. And when my friend showed up, he took me to the hospital. They didn't want to take me to the hospital. They said it wasn't bad.
Who's they?
The defendant and some other people that were there. It didn't look that bad at first.
Did you speak to the defendant after the explosion?
Yes, I did.
What was the conversation?
He was sorry.
What did he say to you?
I didn't think the paint can that I threw in was going to do that. I didn't mean to hurt you. I'm sorry.
He said that to you?
Yes.
You remember that, sir?
I vaguely remember it, Judge.
Well, why would you have said that, sir, if you hadn't thrown the paint can?
Because at the time, I was pretty intoxicated.
So you really don't know what you did? You knew enough to say sorry.
Yeah, I did. I knew enough to say sorry, but I wasn't. There was a lot of people there at the time, and there was bottles being thrown in. A kid threw a bottle in there, was poking at it with a stick. It blew off and took a chunk of his head. I mean, he was bleeding. So it could have been anybody at that present time that threw it in there.
Did you hear anybody else apologize to the plaintiff like you did?
Nope, because no one else, everyone, as soon as that happened, like Ricky had no friends after that. So I went by his house and I, apologized.
That's what happens when you drink too much. Mr. Brusdorf, you indicate that you have a witness with regard to this incident?
Yes, I do. Nick Burke.
Would you step up, please? Tell me what you observed.
Standing there, I seen Dave move towards the fire, dropped something in, came towards me and asked me, "Do you hear that?" I said, "What is that?" He said, "A ball bearing." And I said, "What do you mean ball bearing?" "Ball bearing for a paint can. There's a paint can in the fire." And then I look up and then, bang, blew up before I could get the words out to warn anyone to get away. There was a bunch of people standing real close. He was the only one that got burned bad, but it could have been 3 or 4 different people that were standing next to him.
Thank you. Can I see your medical bills, please? Who is this gentleman with you?
That's Scott Stebbins. He's a good friend of mine. He's my witness.
What does he want to tell me?
Your Honor, I was standing right next to Dave, and I did not see him throw the paint can. I was standing right next to him. And if he would have thrown the paint can in, he probably would have warned somebody.
Well, that's just... Wait one second. The facts. Your conjecture of what he would have done or what he might have done is totally useless in a court. You understand?
Yes.
Did you see any of the other 15 or 18 people who were at the bonfire throw paint cans into the fire?
Not paint cans, Your Honor.
Paint cans is what I'm talking about. Paint cans.
No, they were throwing bottles.
So the only idiot that you saw throw a paint can at some time was the defendant.
Earlier that day.
Well, it had to be within an hour because he was only there, according to him, for a half hour before this incident happened.
But when he did throw that one in, Your Honor, that one exploded. And we knew that it already exploded. And then later on, somebody else threw another one in.
Well, you don't know that, sir, at all. The only person of the 15 or 18 people at the bonfire who you saw throw a paint can at some point was the defendant. Is that right?
That's correct, Your Honor.
Thank you. Sit down.
Judge Judy continues in a moment.
Mr. Brusdorf, I want you to describe for the defendant what it feels like when they do the debridement of burns. Tell him. You have open skin
open skin. It's bleeding. Every time they scrape it, it bleeds. It's excruciating. They tell you to take more pain medicine, but it doesn't work.
What kind
no
of
matter
pain
what.
medicine did you take?
Percocets. I still felt every inch of it.
You understand, sir?
Yes, I do.
Judgment for the plaintiff in the amount of $5,000 as requested. Thank you.
Parties are excused. You may step out.
Judge Judy machinist Daniel McMahon is suing his former live-in girlfriend, 34-year-old store manager Michelle McCartney, for half the deposit on an apartment and the return of his furniture. Michelle is countersuing for Daniel's share of their living expenses.
Order. All rise. Your Honor, this is case number 206 on the calendar in the matter of McMahon versus McCarthy. Parties have been sworn in. Judge, you may be seated. Have seats, please.
Mr. McMahon, according to the complaint that I read, you and the defendant leased an apartment to live together. When you moved into the apartment, you put down half the security deposit. You also purchased some old furniture together. When you separated, you did not receive your security deposit back, nor the value of half the furniture that you purchased. That's what you want.
That's
right?
Correct, Your Honor.
The defendant says this is pretty much a joke because you really owe her money and she has a counterclaim.
Mm-hmm.
When did you lease this apartment?
I believe it was in July of '98, June or July.
And how long did you live together?
On and off for probably a year and a half.
When did you finally separate?
About probably 5 months ago, permanently.
And how long did you actually live in the apartment?
I actually lived in the apartment full-time for approximately 2 months before I got thrown out the first time.
And then you moved back?
And then I moved back.
Well, so let's have all the months together that you actually lived there.
Probably 4 months straight, on and off for probably a year and a half.
And how much was your security deposit that you put down?
$150.
Now, tell me about this furniture that you purchased together.
First, we bought a washer and dryer. I paid $75. She paid $75.
Okay. What's next?
The next is the furniture, which her aunt was selling, and again, we each paid $75 for the furniture.
We did not.
You'll have your
That's
chance.
wrong, Your
You'll have
Honor.
your chance. So that is $275 and $150, $425. How did you pay your half of the rent, which comes to her counterclaim?
With a check.
With checks?
I wrote my checks out to her.
Let me see them.
I don't have them. She packed all my stuff up.
He packed it all himself.
Mr. McMahon.
That's not true.
See, the problem is, she says that you lived together a total of 6 months. You say 4 months. The defendant says that you only paid rent for 2 of those months.
That is correct. But the only reason I paid for the first 2 months because I lived there full time. She threw me out. I had to go move into a whole nother place. And we were broken up. We started seeing each other again, and I had a separate residence.
But then you moved back in, even according to you.
Right, okay.
Sir, listen to me. Then you moved back in, at least according to you, for another 2 months on an apartment where you had a lease.
Right.
And you did not pay rent for those 2 months.
Yes, I did.
No, he didn't.
No, you just told me you didn't pay rent for those 2 months. You said you only paid rent for 2 months.
I wasn't living there full time. I was only spending 2 nights out of the week there. I already moved out into a whole nother place.
No, Mr. McMahon, now you're making that up as you're going
I am
along. You
not,
just said
Your
to
Honor.
me, a moment ago, of the year and a half that you were together, you lived there 4 months, but you only paid rents for 2 months out of the 4.
No, while I was there, if I stayed there for a full month, I would pay for half of that month. If I only spent
That's not what you just told me.
Well, excuse me, Your Honor. I'm a little confused. It was...
Well, let's not get confused, sir.
But I went and got a separate residence, and then we started dating again. I would spend the weekend over there and then go back during the week to my own residence.
He never got his own residence until after the second time I threw him out. He lived with his father after the first time.
Okay, let's talk about the expenses that you say he owes you, Miss McCarthy. Let me hear.
Well, Your Honor, most of what he has said was correct. He was there May and June. I found he was cheating on me, and I threw him out. We reconciled, and he moved back in October, and he was there October, November, and December, and it was shortly after Christmas, 1998, or maybe even after the first of the year, where I threw him out for the second time. He was coming up with all these excuses why he couldn't help me out with the rent, and never paid anything. The day I threw him out, I went to do some laundry, and he had a bad habit of keeping
his, papers in his pants. I would check his pockets for papers, and I found a receipt for some car stereo equipment that he purchased the day before. And that's when all heck broke loose, and I threw him out.
Why?
Because he kept claiming that he had no money to help me out. You know, he was getting speeding tickets. He was paying for the speeding tickets. He bought $1,000 rims for this Mustang that he owned. The heat would be up to 80 degrees, and he wasn't even there.
All right. So now, I got it.
I was on the leaks, though. I'm entitled to turn my own heat up.
Just a second.
But he wasn't paying for it.
I got it. I understand the whole scenario. Now, my next question to both of you is, clearly, according to you, October, November, and December of
1998.
98 is when you, in December is when you threw him out ultimately?
Yeah, it was a little after Christmas, maybe even after the first of the year.
Okay, and did he ever move back in?
No.
Why haven't you sued him for the amounts that you claim he owes you?
Well, initially, Your Honor, we got back together around Valentine's Day in 1999.
So you were back together?
Yes, we did. We never moved. He never moved back in. I still live there today.
But in February of 1999, you sort of got back together. How?
He invited me to dinner, bought me a couple dozen roses, and schmoozed his way back in like he always did.
All right. And how long did that schmoozing last?
On and off for about a year. We had a verbal agreement in between all this because he was upset about the furniture. He threatened to cut it up if he had to in order for him to get his half of it. And once we did get back together, we made a verbal agreement that I was to keep the furniture in my apartment because he hadn't helped me for those 3 months. And that was well and good for us.
Made that agreement.
And all of a sudden I get this lawsuit, and so I said, well, the heck with it. I'm going to just get my money that he owes me.
Okay. That's what I wanted to hear. So you were prepared to say, forget it,
yes, I was.
On. Now, Mr. McMahon, I'm going to ask you the same question, sir. What took you so long to file this lawsuit?
We got engaged.
Yes.
She wanted me to move back in. I said, no, not until some issues are resolved.
And when did that engagement terminate?
On my birthday.
What date?
January 30th. I wasn't just going to jump into a lawsuit until I had some time
you
to deal with what I was feeling.
You should have jumped into the lawsuit a year and a half ago.
Well, yeah, you're right. You're right.
You're absolutely right. If you believe that she honestly owed you this money, half of a washer and dryer for $75 and a lot of furniture for $75.
It's not the money. It's got nothing to do with the money.
So what does it have to do with it?
Your Honor, we had a 3-bedroom apartment. Out of all 3, each bedroom had a closet. I had a quarter of one closet in the master bedroom.
So does my husband.
And I had
let me tell you, he's a happy man.
And I had 2 drawers. I had 2 drawers. I couldn't even put my clothes in there.
He has 2 drawers. Men are lucky if they have a quarter of a closet. They have 1 drawer.
And another thing.
Women need more drawers.
And another thing.
And more closet space.
Judge Judy continues, and McMahon says ex-girlfriend Michelle McCartney won't return his furniture or his share of the deposit on their apartment.
Have you ever been married?
No.
That's a very good lesson I'm going to teach you. Don't expect more than a quarter of a closet. Right? If you expect more, never get married.
Okay, and another thing, January 30th, which was my birthday, which was one of the last big
more than
fights.
A quarter of a closet?
A quarter of a closet's ridiculous.
I've been married for 13 years.
Yeah.
I don't even have a quarter of a closet.
The whole apartment had her family all over the wall. I couldn't put any. I had no entity in there at all.
You mean you couldn't have a picture of your mother or your grandmother up?
The walls were full. I couldn't do nothing.
Mr. McMahon.
I'm serious. She took over the whole apartment.
Mr. McMahon.
I had no rights in nothing.
That's what ladies do. They make a nest.
We need. There should be a little bit of compromise.
Let me explain something to you.
Not.
That's what happens. They make a nest, right?
What about me?
My husband knows he can decorate anything in his quarter of the closet.
I didn't get.
Period.
I had to step over.
Don't move a lamp.
I had to step over shoes to get to my quarter of the closet.
Get over
her
it.
shoes.
Listen to me. Your lawsuit, Mr. McMahon, is nonsense. And so is your counterclaim. Nonsense! 2.5 years ago, you started a relationship. You moved into an apartment together. It didn't work out. Your entire investment was at most $425, which includes $150 for some old furniture and an old washer and dryer. How many times did you use the washer and dryer? I want you to think very carefully. How many times did you take clothes, like sheets and towels, from the bathroom and from the beds, take them, put them in the washing machine, wait till it was finished, take it out, put it in the dryer, and fold it up? How many times did you do that?
Plenty of times. If I wasn't being thrown out that week, I was doing laundry.
If you weren't being thrown, you were doing laundry?
Yeah.
Is that right?
I used to do her work clothes for her. Everything else.
He was doing the laundry?
Some.
He was doing
few and far between. I was mostly doing all of our laundry. But yes, it was used for his clothes, which he had.
I didn't ask you it was used for his clothes. I'm talking about sheets and towels and stripping the beds. And
oh, I did all that. I could hardly even get him to make the bed, never mind strip it.
I'm talking about stripping the beds and putting the sheets in, and putting the sheets back on the bed. Who did that?
I did all that.
You did that?
Yeah.
Well, you were honest about the other thing. He did to his own work clothes. Who did the cleaning in the apartment?
I did everything. I did everything, Your Honor.
Like what? I mean, who scrubbed the bathroom floor? Who scrubbed the kitchen floor?
I did. I wouldn't even let him do the dishes because he would do them in a half-mannered way and they would be all greasy, so I'd have to redo them anyway. That was his lame excuse for not being able to do anything because he didn't know how.
It's called learned helplessness. You do it wrong so nobody asks you to do it again.
That's not
Mr.
true at
McMahon, is it accurate that the housework was done by the defendant?
You know what? I didn't spend enough time in that apartment to clean anything. If you want the real deal.
You spent some time there, sir. According to you, you spent a couple of months there straight. And in addition to the couple of months there straight, 2 or 3 days a week when you were going to your own place. So you were there long enough to dirty the kitchen, dirty the bathroom, dirty the tub, dirty all those things.
If I dirtied something, I cleaned it.
That's that. I've heard that before. Mr. McMahon, your lawsuit is nonsense, and so is your counterclaim. They're both dismissed. Get over it.
Parties are excused. You may step out.
One of us was obligated to continue paying that lease, and I did, and I have been paying it ever since. He paid 2 months, and he was on a lease for a year.
He wanted me to pay it while I was living in it.
Oh, well.
I didn't get treated fair in the relationship from Jump Street, and, you know, I got taken advantage of.
And now the next case.
All parties on Sias versus Graham. Step forward, please.
55-year-old Asian arts instructor Ted Sias is suing 19-year-old carpet installer William Graham for assaulting him while riding his bike.
According to your complaint, Mr. Sias, you were riding your bike to work. What kind of work do you do?
I teach internal health arts in Huntington Beach.
In a school?
Yes, ma'am.
And a car that was being driven by one of these two young men,
Mr. Graham,
somehow passed by you, and he shouted something out the window, which made you angry.
It startled me. It scared
Startled
me.
you?
Yes.
So you got angry?
Yes.
And what you did in response was to ride your bike on an overpass where you were, and when you saw his car passing under the underpass, you picked up a rock and threw it at his car.
Yes, ma'am, but it was actually a pebble, and I brought the approximate size that I dropped.
Pebble, rock, you threw a something at his car.
Yes.
That made Mr. Graham very angry, right?
Ma'am. Yes, ma'am.
And you got off the expressway to find him,
Yes, ma'am.
because you saw him do it.
Yes, ma'am.
And there was a confrontation. And that's what this lawsuit is about, because you said that during the course of that confrontation, Mr. Graham injured you and broke your bike.
Yes.
So let's start out. You're pedaling along, going to work. His car comes alongside you, and what does he say to you?
It wasn't him. It was his passenger that screamed at me.
What did his passenger say?
I don't know. It was just a holler, a very loud holler. I wasn't.
Which startled you.
Yes, ma'am.
And then what did you do?
Well, I about fell off my bike. Then I picked up this little pebble, and I was thinking about dropping it. And when they pulled around, then he gave me the birdie. That was it. That's all it took to send me the rest of the way. So I did drop it. I wasn't dropping the pebble to cause damage. I was dropping the pebble as more of an act of, you do this to me, I do this to you, but I wasn't striving for revenge. I lost my head.
Yeah, but he didn't do anything to you, sir, that involved any physical touching.
I think
his
it's
passenger
Yes, ma'am.
said something to startle you.
I think it's an accumulation of years of riding and getting people throwing things at me and hollering at me. I guess that one time I've been tired. I was riding my bike for 12 miles that day. I just lost it.
Judge Judy continues in a moment.
You see the passenger?
Yes, she was, ma'am.
Did you do that? Up! Right there.
Real cases, real people. Judge Judy. Ted Sias says William Graham assaulted him while out riding his bike. William claims Ted threw a rock at his car.
What was the first thing that was said?
I asked him, ma'am, I said, why did you throw a rock in my car? He then got off his bike, and he says, well, you know, you screamed at me. And I'm like, who screamed at you?
Well,
you know,
it's clear he didn't scream at you. Just a minute. He didn't scream at you.
Yes, ma'am, he didn't.
Somebody else did. Go ahead.
It could have been possible that we had been goofing around, laughing, whatever, you know, the case may be in the car, what you do with people.
Whatever. Somebody in your car spooked him. Right?
That must have happened somehow. It wasn't intentional.
Was he the passenger?
Yes, he was, ma'am.
Did you do that? Oh. Up! Right there. Right where the finger is. Did you do that to the bike rider?
I was...
No, look at me.
I'm sorry. I was singing in the car, yelling, having a good time, not yelling at anyone out of the car, intentionally.
Did you realize you had startled him?
No.
Now sit down. Go ahead.
Okay, so then he pushes me once. I push his hand down. I say, don't touch me again. He pushes me again, I push his hand down, and after I push his hand down the second time, he shove-kicked me to my groin area, and I didn't do anything. Then I was going to call the cops. He got on his bike like he was going to leave, and I said, where are you going? And he said, oh, I'm leaving now, like that, and he's like, you're wasting my time. I said, yeah, thanks a lot, I just got my car painted. I just got my car painted, and he dropped a rock and chipped like on the roof of my car. And he says, well, now it just gives you something to do, doesn't it? He gets back off his bike, pushes me one more time, I push his hand down again, and then he kicked me harder in the same exact area, the same type of kick in the groin. And at that time, I grabbed his leg. He went to swing at me, and I hit him in the head, and then I hit him a couple more times. He fell over his bike, which was right behind him. Once he was on the ground, I held him down. This is all in a position where I had a broken collarbone at the time because I was in an accident maybe a month before at the most, and I had a cast on my hand from torn ligaments. So I was really in no position to be starting a fight.
What kind of accident? Car accident?
Yes, ma'am.
Mr. Sayers, you want to tell me your version of the event, sir?
Basically, he's saying something effective. You're going to pay for it, you're going to pay for it, or you're going to apologize. I can't remember which one or both. And he kept trying to get closer to me, and I kept telling him to stay away. I said it numerous times. I did what's called a push kick towards his groin. It was not meant to cause any pain. He says, what was that?
But you did do that.
I did do that, yes, I did.
And he hadn't put his hands on you yet.
He was kept getting...
No. He had not put his hands on you.
No, ma'am, not yet. I did what I could, which was non-lethal. I pushed towards his face to make him lean back to go away. I pushed towards his groin.
He didn't kill you either, Mr. Sayers. That's not lethal.
If you look at the picture, you'll see it's probably lethal. My face doesn't look too pretty. I probably got a birthmark that'll last me the rest of my life. You want...
Sure, I'll take a look.
Thank you.
Mm-hmm. That's not lethal. Nasty, but not lethal.
Judge Judy will continue in a moment.
You don't say anything in your complaint, Mr. Sayers, about your putting your hands on the defendant first. He's a young man, and very often people say, well, young kids, you know, they're going to lose their temper and they're going to get out of control. I think that it happens with men when they reach maybe age 50. You're not 50 yet, are you?
Nowhere near.
I know, they do have as sometimes what you describe as road rage. You went to the top of an overpass, you picked up a pebble. You say it was a very small pebble. It may have been, but certainly enough. If that falls on your car fast enough and shatters a windshield, that can cause you to lose control of the car, and it can cause you to go into a tree, another car, another person. It can cause very serious damage, injury, and can cause death. And then when he confronted you, when he stopped the car, which was his absolute right because he had done nothing to you, his partner over here maybe was singing too loud, maybe he was trying to frighten you, maybe he was acting like a jerk, which is possible, because I'm looking at him, and it's possible. But he didn't do anything to you. When he confronted you, instead of apologizing, you put your hands on him first, twice. And it looks to me, at the end of the day, you got the worst of it.
Obviously.
That's too bad. Your case is dismissed.
Parties are excused. You may step out.
Judge Judy will continue, and his wife Linda are suing their sister-in-law, 42-year-old Diana Kane, for an unpaid loan and funeral expenses for Diana's late husband.
Order. All rise. Now, this is case number 116 on the calendar in the matter of Pelletier versus Kane. Parties have been sworn in, Judge. You may be seated. Ma'am, have a seat, please.
Mr. Pelletier,
Yes.
It was your brother who was married to the defendant?
It was my wife's brother, Your Honor.
Your brother was married to the defendant at the time of his death.
Yes, Your Honor.
However, it's a rather long story before that, according to your complaint. According to your complaint, your parents were also alive, and there came a time when they came to live with you?
Yes.
And they came to live with you because they were in failing health.
Yes.
And at the time they came to live with you, your brother was living with them.
Right.
He had suffered a breakdown of some sort, and he was living with and being cared for by his parents.
Yes.
So you decided to take your mother, your father, and your brother into your home.
Yes.
Shortly thereafter, your father passed away. Is that right?
Yes.
And shortly thereafter, your mother passed away, several months later, leaving your brother. You okay? Your brother was, for both ladies, Bird.
No, I don't need one.
Your brother was visiting someone, and he suffered a heart attack?
No. He was in jail in South Carolina.
He was in jail?
Yes.
After we had got him out of the hospital, Your Honor, his last stay in the hospital in November of '99, he was very bad off, and we still tried to...
He was in a psychiatric hospital?
Yes, it was, ma'am. We still tried to maintain some semblance of living for him, and we still maintained the apartment that we had gotten for her mom and her dad, and we left him in there, let him stay in there. We supplemented his income and helped him with his monthly expenses. He, one evening, had taken his mother's automobile and left without telling anybody. I received a call on a Saturday afternoon that he had been incarcerated in South Carolina for some frivolous type crimes up there.
And how did he die in South Carolina?
He committed suicide in the jail, Your Honor.
Okay, and what did you do?
We were notified by the Clarendon County Jail that evening, and I immediately called the defendant, his estranged wife, and let her know that he had committed suicide, that he was dead. And we had several subsequent conversations over the next couple of days, and we had started making the arrangements, and that we were going to travel to South Carolina to pick up whatever personal effects he had left, along with his remains. And I had talked to the coroner up there, and we had made all the arrangements. I had very nice conversations with Mrs. Kane. We agreed, we bought her a plane ticket to come to Florida. We was going to let her stay in our home. We had a service planned for January 14th. We arrived in South Carolina on January 11th that afternoon, stayed there that evening. 9 a.m. I had an appointment with the coroner, the medical examiner.
Was Mrs. Kane there?
No, she was not.
Go ahead.
9 a.m. we walked in, and he was there with the chief of police. And they were very sad to inform us that they'd been notified the day before that Mrs. Kane had already obtained a lawyer in Sumter, South Carolina, pursuing charges, and that they notified the funeral home that if they released his remains to us, they were going to take legal action against them. So, Your Honor, in the 30 years that I've been married to this lovely woman, that was absolutely the hardest thing that I have ever had to do, was to leave there. And there were tears in everybody's eyes that day, that we could not leave there with his remains.
So tell me exactly what you are suing her for.
There was a loan that the defendant had with my wife's parents, a $2,500 loan that they had gotten from my wife's parents in November of 1997, which they were making regular and reoccurring monthly payments. And I have a detailed log of that my wife's mother kept. It's in her handwriting. It's not an agreement, but it's a very detailed ledger log that she recorded every payment she received from the defendant.
Well, the defendant says that she and her husband were in fact making payments on this loan until after your father-in-law died. She says that your mother-in-law then said to her, you don't have to bother to make any more payments on this loan. Is that what your defense is?
I understand that, Your Honor. I had a conversation with Mrs. Kane, my wife's mother, Sarah Kane, in July of 1999. We were helping supplement her income also, and we had a discussion about this, and she was depending on that money to live on. She was on a very fixed income, and I told her then that she needed to notify the defendant and tell her to keep on making those payments.
Is there any evidence that after July she resumed making the payments?
No, there is not. The logbook goes up to July.
So then, what you're saying is there was, in fact, in all probability, a conversation with her about not making the payments, because you told her that she should resume making the payments because you couldn't continue to subsidize her.
Exactly.
Well, but there is no information that she did, in fact, tell her the loan is not forgiven.
No, there is not, Your Honor.
Well, then,
there is not.
Clearly, from the evidence that you have just presented to me, it is a problem, because if the payments stopped on or about the time of your dad's death and did not resume, and you clearly, Mr. Pelletier, had a conversation with your mother-in-law and said to her, well, you can't let her stop making those payments to you.
Right.
That means she must have said to you, I told her she didn't have to make the payments anymore. Because your response was, well, you have to tell her she has to start making the payments again.
Exactly.
But then there's no evidence that she did.
That's correct, Your Honor.
Okay. So then let's not deal with the loan. What else are you suing Ms. Kane for?
After that point in time, after January 12th, Mrs. Kane stopped taking all of our phone calls concerning the arrangements or what was going to happen. So we canceled the service in Florida and never was able to talk to her. On January 26th, I received this letter from Mrs. Kane informing us, and it's here in the letter, that she wanted us to go to South Carolina again, pick up the ashes, bring them to Florida, and have a service. I immediately called the funeral home, and they informed me that no, indeed, that was not the case. The following Monday, I received a call from the defendant's daughter saying that, well, now she's changed her mind again. On or about February 1st, I made another phone call to the defendant. I told her, I said, Diana, it's been a month since you left his remains at the funeral home. We need to do something. We're in grief, and it's a very, very hard time. So finally, I called, and I talked to her, who was the head of the funeral home. I said, I'm sending you a check for $1,485. I want you to send the ashes to Maine. And we had moved the whole service and planned a big service up in Maine on February 5th. We traveled to Maine on the 4th and get to the church, our family church, on the 5th, and all the friends and relatives were there. The ashes were not there, and the defendant was not there. To this day, Your Honor, we still do not know the whereabouts of the ashes or any of it.
Judge Judy continues in a moment. Reggie and Linda Pelletier say their sister-in-law, Diana Kane, owes them for an unpaid loan and for her husband's funeral expenses.
Okay. Tell me, Mr. Pelletier, what money you're suing her for?
We are suing her for the $1,485 that we paid to the funeral home.
Well, did she agree, Mr. Pelletier, that you could make the arrangements to have the ashes sent to Maine?
Oh, absolutely. I talked to her on the phone, her and her daughter, and on February 1st, I spoke to both her and her daughter, said, I'm sending a check, federal expense, to the funeral home. The ashes are going to be shipped out immediately. We posted the obituary in the paper and informed her.
Okay, but no, but did she say okay? Or did you just tell her?
No, she said okay, that was fine. She wanted us, I said, we need to have a service, and we shipped the ashes to Maine, and she agreed to that.
Did you agree to that?
No, I did not.
What, you want to talk?
Yes.
Who are you?
I'm her daughter. I'm Melissa Woodway, and I've been with my mom, and I've been doing the phone calls with Reggie. I had a phone conversation, I believe it was on February 5th, I believe, pertaining to the ashes. We agreed, I remember my mom writing that letter for us to go to, I believe, Florida and spread the ashes on in the ocean. Only did we receive that they had forged my dad's name and draw out all of his money out of his account on the day of his death. And only he said to me, he said, I will send the check, Federal Express, right now, if you call your lawyer and do not press charges on my wife for forging the checks. That was what he said to me. It was not an agreement. That's how it went.
Okay. Let's deal with these checks because this is part of a counterclaim. Did you ever draw money out of your brother's account?
Yes, I did. Absolutely, Your Honor.
Okay. When was that?
That was on February 6th, Your Honor.
There was January 5th and there was January 10th. And we have the checks here.
Can I see the checks?
You read the checks, ma'am.
Your Honor, we have the deposit slips where we had deposited the money in his account.
I'm going to take a look at everything, sir.
The day of his death, they did this.
And I have the checking account on back. They forged my husband's name, and they put their money in their checking account.
See, my mom has been going through a lot. She's a lot, so I've been standing by her through all this. Now, also is, during the phone conversations, there was a matter of 25 phone. I've never spoken to Linda. I've never met her before, and it was nice meeting you. Reggie, I had spoken to Reggie because since they had drawn this money out of my dad's account, I figured that was enough to pay for the funeral, I mean for the coroner and for the cremation. They refused. They refused to send them to have that money. That was their money.
So tell me, where did this money come from that you, where do you claim it came from his account?
He got, sorry.
There was $920, Your Honor, that was acquired from the estate account of Sarah Kane for the month of November and December. The balance of that was $800 that was in his account. The $2,588, as you can see, we deposited in his account.
From where?
That was the proceeds from a life insurance policy, of which he was entitled to 1/4 of that.
So that's his 1/4.
No, his 1/4 of the $2,588.
So why did you deposit the whole thing in his account for?
We deposited the whole thing in his account so we could disperse it out of his account. I mean, that's the way his mother wanted it.
Well, that makes it a little too complicated, sir. But even if you deposited that money in his account, this becomes his money. You can't, by law, write a check and sign his name. You understand that?
I understand that, ma'am.
Okay, so you can't do that. And if there was money put into the account, $800 was his?
That's correct.
Was his?
Yes, it was.
Okay. And according to you, 25% of $2,500
Exactly.
would have been his.
Exactly, Your Honor.
Right? Which more than covers this $1,485.
That is correct.
Right? So that would at least make this a wash with regard to money.
Correct.
Right?
Yes, ma'am.
Okay.
Judge Judy continues in a moment.
Is there any way I could show you some pictures of their home with my dad?
No.
No?
For what?
To see a picture of Fred.
No, I don't have to see Fred.
Real cases, real people. Judge Judy. Reggie and Linda Pelletier say their sister-in-law, Diana Kane, owes them for an unpaid loan and for her husband's funeral expenses.
Now, Ms. Kane, you have a counterclaim for these checks and for a lot of mental anguish.
Yes.
So I have a few questions for you. How long had it been since you hadn't lived with your husband?
I lived with my husband for 2.5 years, but I was going to Florida to see my husband.
When were you married?
June 21st, 1996.
So you weren't married very long.
But we've been 4 years this month.
But you didn't live together for 2 years.
Due to his parents being...
Just a second. You didn't live together for 2 years. He lived with his parents.
Right.
You were separated from him for a while. He had a mental breakdown?
He had a breakdown back in January 27, 1997. He was home with me.
And after that, he went and lived with his parents for a while.
And he came back home.
What?
Okay. He had gone to Florida because Nana and Papa were sick.
He stayed there.
Right, he stayed there with
all right.
Nana
He was
and Papa.
separated from your mom.
Right, they lived in
Okay.
different residents,
They-
yes.
That's what separated means. He was
Right.
separated from your mother.
Right.
Is there currently a lawsuit against the state in South Carolina that was filed by you or your mother on behalf of your father's estate with regard to him committing suicide while in the jail?
Yes, we...
Okay. I know that.
Can I elaborate a little bit more?
No, you don't have to elaborate. I could have told you that. You hired a lawyer, and the lawyer said if you commit suicide while you're in jail, that means the county is negligent, and that means that you have a good lawsuit.
Right.
And you hired a lawyer for that.
That's right.
Okay. What's the status of that case?
We're not too sure of it right now.
Okay. Can I finish Reggie's case, please?
No, not necessary. They're not getting any money because these checks covered that money.
Is there any way I could show you some pictures of their home with my dad?
No.
No? I'm just saying.
For what?
To see a picture of Fred.
No, I don't have to see Fred.
Okay.
Pay attention.
Okay.
This is all about money.
It shouldn't be.
It is all about money.
Okay.
That's what it's about. That's why you hired a lawyer.
Right.
To sue, right?
Right.
Where are Fred's ashes? That's what I want to know.
I bought an urn.
What?
I bought an urn for my husband.
Where are they now?
They're at home right now with me.
Yes. Yeah.
Miss Pelletier, I'm going to just try to make you feel a little bit better, if I can. I got this case. I got it. Did your brother have any children?
No, he...
Do you know if he had a will?
No, he did not.
He died intestate, Your Honor, no will.
if he died intestate, you understand, even if he was married to this lady for an hour, she has the right to make the funeral arrangements. She has the right to take the ashes or the body. She has the right to do all of that, even though he was your brother for a lot longer than an hour. Be nice if you could see the ashes. They're really not important.
I know I put my mom and dad in the same bay, and that's where he would have wanted to go.
Okay. But you can't make that judgment because that's not what the law says. The law says you cannot make that judgment. The law says that the person who is the next of kin, and in this case, even if they were separated, she's the next of kin. And she's permitted to make those... Stop playing with the papers over there.
Judge Judy continues in a moment.
Now, how long did you know Fred?
I knew Fred since 1995.
So for a very, very short period of time, you knew Fred as an adult. He didn't raise you. He didn't raise you. You met him in 1995. According to your mother, in 1997, which is less than 2 years, he had a nervous breakdown.
Right.
So don't tell me about the love that you had. All right? That's her brother.
That's right.
If anyone should be involved in making the arrangements and making sure that his last wishes would have been fulfilled, your mother should have consulted them and done that. She didn't. Everybody got very excited and very involved about hiring a lawyer and suing the county where he committed suicide. His memories and his soul are most important.
That's right.
You have that. And there is nothing that any court is going to do to make you feel better about that. You know, your husband is very articulate. He told the story very well. This was the wrong thing to do. I understand how it happened. I would assume that nothing is going to come of it. It should not. But you never can tell when people are interested in money. You never can tell what they're going to do.
That's correct.
Don't worry, she's not going to jail. That's all.
Parties are excused. You may step out.
20-year-old contractor Richard Calmetta is suing former friend, 23-year-old medical marketer Sarah Ann Morris for failing to pay him for painting her condo and for airline tickets to South Beach.
Order. All rise.
Now this is case number 182 on the calendar in the matter of Calmetta versus Morris. Parties have been sworn in, Judge. You may be seated. Folks, have seats, please.
Mr. Calmetta, according to your complaint, sir, you met the defendant at Home Depot.
Yes, Your Honor.
And you just struck up a conversation with the defendant.
Yeah, she was standing in front of me in line.
And she told you that she was buying stuff to paint her house or to do her house, and you volunteered to help her, but then indicated to her that the cost for doing that would be how much?
Well, Your Honor,
$1,500?
oh, I'm sorry, Your Honor, I don't mean to change it. But what had happened was I had given her my card because I was sort of attracted to her.
I assume. I've read the complaint.
It wasn't more or less, I told her she did need electrical work. I was an electrical contractor. I do building, I do painting, I do remodeling, but my primary job is an electrical contractor. So I handed her my card, and I did make a comment that is sometimes it's easier to hire someone to do the work than try to do it yourself.
So?
Well, about 3 hours later, I went and finished the job I was on, and I got to the driveway of my home, and I got a phone call on my cell phone. It was her, and she had tried to attempt to paint the condo herself, and she was having a little trouble. Apparently, the paint wasn't sticking to the ceiling, and she was getting blotches, and I sort of told her, I says, well, try to smooth them out.
Well, what did she ask you? She said, how?
Well, she asked me if I knew someone who could come out, because she knew that my primary trade was electrical, that if I knew a painter, if I could help her out. And I says, well, sure, I do, but it's going to be very difficult to get someone to come out on a drop of a dime. You know, this is Friday night, you know, and figured I tried to make a few phone calls, and nobody was calling me back.
You didn't make any phone calls. You decided to go over there yourself.
Yeah, I did. Well, I did call one person. I tried to. I called one person.
You thought about calling somebody, but you went over yourself.
Yes.
Mr. Calmetta, let's keep it simple, sir.
Yes,
simple and honest. Yes.
So
okay.
I ended up going over there, yes, and I noticed that her rollers were incorrect. She had the incorrect rollers. The paint was a cheap brand, and I asked her, I said, let's go to Home Depot, let's get a better quality paint, and let's get some rollers. So we went to the store, we picked up the correct supplies, we got back, and I did spend that whole, I got there from 4, I have the whole job itemized here.
No. Just tell me the stories.
Okay, I'm just.
You didn't
letting you know
itemize the job that day or
No,
the day
it
after.
was itemized down the road.
It was itemized down the road, close to this lawsuit.
Yeah, right at.
All right, so let's, Mr. Calmetta, let's try to keep it simple. So you
understand.
went to this store, you got better paint, and you got a couple of really good rollers, and then you went back and started to help her paint the house, right?
Yes.
Okay, let's hear.
Well, we spent the whole week in there painting because it was a decent sized job. I had my employee here come by on Saturday. I was there till 11:30 Friday painting, and we returned Saturday in the afternoon after I was done with my regular jobs, and we spent. Well, I had left for 2 hours. He was there for the first 2 hours while I had went and did a service call. I returned. We were there together for about 5 more hours, and I stayed later to try to finish up the job on
What
Saturday.
are you talking about?
Shh.
Sorry.
Go ahead.
That was May 6th on a Saturday. And then the last day I was there was Sunday, which was May 7th. And I was only there for 3.5 hours.
Okay, so you were there. Did you finish the job?
Yeah, we finished the whole job. It was
Good.
like, she wanted 2 different colors, so that took a little bit of taping.
You finished the job.
Yes, ma'am. Yes, Your Honor.
And then what happened?
Well, there was also, things happened, and we talked about possibly going to South Beach with me. Okay, we were going to
Going to Florida?
Yes, Your Honor. And I had purchased some tickets for us to go.
When did you do that?
Actually, it was Monday.
I mean, right after the weekend?
Yeah.
Right after the weekend, you bonded with the
Well,
good rollers.
At least I thought we did.
And?
And when it got closer to the trip, I'll try to make this short, something happened to her grandmother.
How
got
much
sick.
later was the trip scheduled?
Well, it was scheduled to leave on the 19th of May.
So within a couple of weeks?
Yes.
Okay. Did you see each other between that time, between the Monday that you finished the job and the day you were supposed to leave on the trip? Did you go out? Did you date? Did you go to dinner? Anything?
Well, we were both quite busy.
So the answer is no? No. Okay. And?
Like I said, 3 days before the flight, she had called and said that well, I tried to get in hold of her. She's kind of mad. Called her work. She didn't like the fact that I called her at work. I didn't think it was that big of a deal. She was at her grandmother's house for a couple days. Apparently she was sick and she couldn't make the trip, and she ended up canceling on me, which in a way I did go on the trip by myself. I have the tickets, that I purchased for her, which I'm not too concerned with about the trip, to be honest with you. Even though I put it on the sheet, I wasn't really going to try to make a deal out of it, because I did go on a trip and I had a great time. The day I got there, I met a beautiful young lady and had a great time in South Beach, and I was kind of glad I went. So it turned out real well. So more or less, it's the trip's not that big of a concern. It's just more or less the work that I did.
So you are withdrawing your claim for the plane ticket?
Yeah, it doesn't matter.
So far, that's a good idea, because I didn't hear anything about, well, I'll pay half.
Yeah, exactly. So I figured
good.
that much. So
Perfect. All right. Now, with regard to the painting, I also didn't hear anything, Mr. Calmetta, about how much she was going to pay you or your helper.
I was going to tell you that. I don't know how you could figure as far as the Friday, because we didn't discuss the rates till about the middle of the job on Friday. She goes, well, what do you charge?
She asked you what your fees were. That
Right.
doesn't necessarily mean that she was agreeing to pay your fees. But
Well,
she asked how much.
When they ask me what my fees are, I'm not there to do this for free. I wasn't there to paint the place for free. I more or less made it clear that $75 to come out, and it's $50 per man per hour. Those are my daytime rates. Anything after 5 o'clock, like I said, I have it all itemized, it's double time after 5. Saturday, it's time and a half, and Sunday, it's double time. And I did make it clear to her, I even said it'll probably run about $1,500.
Okay.
And so,
Now,
but it did come a little bit more than that.
now, when you told her it was going to run her $1,500, what did she say to you?
She had no problem with that.
No, what did she say? Hi.
She said okay. She had no problem with
Okay,
it.
now, Miss Morris.
Yes.
Let's hear from you. And we don't have to concentrate on the trip, because the trip he's withdrawing, because
I understand that.
He had a great time there with somebody else.
Judge Judy continues in a moment. Richard Calmetta says former friend Sarah Ann Morris owes him for painting her condo and for airline tickets to South Beach.
Now, Miss Morris.
Yes.
Let's hear about the painting. You hooked up at
Your
Home
Honor.
Depot. I assume all of that is correct, that you met there, that you called him to come over and take a look and see if he could help you, that you did in fact go back and buy different paints, different rollers, etc. He came back to your house and started working. So far, is that all correct?
To a point. He gave the wrong dates.
It's April 28th.
Who cares?
29th. My family was supposed to help me, and they canceled on me. So I was desperate to a point that I needed to get it done. I'm just a go-getter. Once I say I'm going to do something, I like to accomplish it.
Okay, so you called him.
Yes, I did.
You didn't expect him to do it for nothing, did you?
No, I didn't.
But you just, because you just met the man at Home Depot.
Right, I expected to pay him. No, yes, I did, Your Honor.
Oh, so how much did you pay him?
I offered him Saturday $200. He refused to take it because he began liking me.
Well, ma'am, I do a service call for $20.
He wouldn't take the money because he knew I'm a young lady. I just got started on my own, and he didn't want to take from me. He makes his own money. He doesn't need $200.
Well, this man didn't like you. You were the helper?
Yeah,
right?
he's my employee.
Just a second. He was the employee. He was there painting with him. He wasn't crazy about you. What did you think? He was just coming along because he had nothing to do for the weekend?
No, Your Honor, I wasn't.
Well, what did you pay him?
I didn't pay them anything because he told me he didn't want anything.
What about him?
He was just his follower. He spoke for both of them.
Miss Morris.
Yes.
Pay careful attention, madam.
Will do.
You called him because you needed somebody to paint for you.
I told him yes.
And you expected to have that done at a fee.
Right.
I assume you were helping.
Yes, I was.
Okay. She was helping.
Yes, you.
And that isn't the usual standard fare. I mean, I've had my apartment painted, and I don't remember being right in there in the thick of things with a paintbrush when somebody's painting my apartment. Like, if you went to do an electrical job, sir, you wouldn't say to the person whose house you were in, come over here and hold these wires because you're going to hold the wires while I hang the fixture. You come, they leave, and so this was a little different.
Because we were on time and material.
No.
Yes.
It was a little different.
Well, we were on T&M, though. I did discuss as far as, she was trying to say
Mr. Calmetta,
well,
it was a little different.
Yes, it was.
And it was a little different, compounded by the fact that the day after you completed the job, you made an investment in plane tickets to take it to South Beach. How many times have you done that when you did your electrical work? Right?
Yes, right.
All right, so it's a little bit different. You see, my problem, Miss Morris, is that you can't be a total taker. I mean, if he's smitten with you and he wants to invest a weekend helping you paint your condo, that's fine.
I agree.
But this man deserves to be paid, especially when it certainly appeared that after the painting was done, you had nothing to do with him, even after he bought the tickets and then bailed out. Right?
Correct. But
right.
A lot of things in between that we're not discussing right now happened between mine and Richard's relationship, or friendship, I should say, to make me not want to go on this trip with him.
But I withdrew the trip.
I understand.
So drop that.
Just a second. That may be. Don't you understand that a man who is smitten with a woman, whether he's good, whether he's bad, whether he's got quirks, whether he dresses up in odd clothes in the evening, it doesn't make any difference. You know, he feels as if he had made an investment because you led him on over the weekend. You led him on sufficiently for him to plan a trip with you that you initially said you would go on. Initially. What are you shaking your head? No. You mean you didn't initially say that you would go with him?
Not really. I was too good to be true. I didn't believe it.
Just a second. Don't tell me too good to be true. You initially said that you would go with him. He didn't go buy tickets to South Beach.
He already had the tickets bought, Your Honor. He came to my house with the tickets a week before we were supposed to go with somebody else's name on the ticket saying, I was supposed to take her, but instead I chose you.
Is that true?
Show her the ticket.
Is that true?
Well, I was supposed to take somebody else on a different date, on a different flight, some other girl that I had met. But, but it has nothing to do with...
Would you step up here, sir?
Your Honor, it has nothing to do with her, though. I mean...
Please. It has enough to do that you put it in your complaint, sir. Tell me your last name.
Szynski.
Mr. Szynski, you work with or for the plaintiff?
Yeah.
How many hours did you spend approximately at the defendant's house?
Saturday from 4 to about 11 o'clock.
Just on Saturday?
Yep.
Okay. Let me see your job estimate that you've made up right before court. Okay. Now, you say that you get $50 an hour.
Yes, Your Honor. That's standard contractor's rates.
For you and for...
It's per man per hour. The way
per man per hour.
We charge 75...
Mr. Calmetta, I don't believe you, sir. I don't believe that you had a discussion with her prior to you doing the job, fixing the fees, including $50 an hour for you and $50 an hour for Mr. Szynski over here.
I have overhead as far as
Pay
phone
attention,
bills.
sir.
Yes, I understand it, but that's
Pay
what I charge
attention,
as,
sir.
as an employer, though.
I don't believe you had an agreement with her.
I had told her what the rates were.
I had told, listen to me, sir. I don't believe that you had a contract with her. There are too many things that do not ring true to me, including the fact that you prepared this right before you came to court. You had no signed contract. When you do an electrical job for somebody, Mr. Calmetta, you prepare this first, right? Pay
Your
attention.
Honor, I don't.
Mr. Calmetta.
You're not saying that. You want me to,
Mr. Calmetta,
you're telling me how I do my
don't try to
business.
talk over me, sir. You're going to lose.
Judge Judy continues in a moment.
You better make up your mind quickly what we're going to do about the situation. It's not going to go away. If I don't hear from you by the end of the day, I'm going to make your life miserable.
Real cases, real people. Judge Judy. Richard Calmetta says former friend Sarah Ann Morris owes him for painting her condo and for airline tickets to South Beach.
Mr. Calmetta, if you are an electrical contractor or a building contractor, and I have dealt with both.
I understand, but
when you do a job, you outline what the job is: cost of hours, cost of paint and materials, cost of electrical supplies. You sign it, and they sign it.
That's on a bid. This was not a bid.
That is not a bid, sir. I have never dealt with anybody on a big job for $1,500 or $2,000 where we didn't have a contract. Even a painter. The painter writes down what color they're going to paint the foyer, what color they're going to paint the living room, what kind of paint they're going to use. I sign, they sign, I have a contract. And if you're in business and if you have employees, that's how you do your electrical work as well. And if you don't do it, then you're not a very good businessman. This was done later. I don't believe that you had a contract with her, but I do believe that you are responsible to pay Mr. Szynski. Do you understand? You can't be a taker.
I don't want to be a taker.
Good. So how much do you think it was worth for you to have your condo painted over the weekend at the drop of a dime? You tell me how much you anticipated paying somebody else.
The estimate that I show for the work that they both did came out to about $300 worth of work. I'll be willing to pay
That's ridiculous.
Richard $300. His
I do that
partner.
on a service fund, Your Honor.
I have a tape here, also, Your Honor, that has him threatening me and also saying that he did the paint job out of the goodness of his heart because he liked me.
Oh, well, let me hear it. Let me hear that part. I want to hear the
It's three
threats.
different messages because it...
I just want to hear that he did the paint job out of the goodness of his heart because he liked you.
Okay.
Yes, Sarah. We're going to need to hear from you today. We're going to have to figure out what you're going to do about this situation. This needs to be taken care of. I gave you my time. I spent a whole weekend over there painting your place. For the goodness of my heart. My time is very, very, very valuable. I did that out of the goodness of my heart. Spend time with you because I liked you. What a mistake that was. Knew when I handed you my card that I was interested in you. That's why I even came over. You weren't attracted to me. You should have never had me come out there. You knew why I came out there. Why I stayed out there. Then the situation the way it went, you should have never accepted an invitation to a trip. But you did. Went and spent money on tickets. I'm not going to eat these tickets. The trip is Wednesday. You're either going to take the tickets and go on the trip, because I'm not going alone. Now again, I'm not on a drop of a dime. I'm going to find somebody to go on this trip here in a couple days. Now I'm not going by myself. You better make up your mind quickly what we're going to do about this situation. It's not going to go away. I'm going to make your life miserable. Not only will I make it miserable by suing the out of you, and maybe some other things too, I'm going to pull some strings at your job. So I'm going to spend the whole day tomorrow on a mission of getting back at you for what you've done to me. Now, I don't want to have to do all this. But if I don't hear from you by the end of the day, first thing I'm going to do tomorrow, I'm going to pull some strings, because I know people. I don't want to have to do this, but I will. Now, if I don't hear from you, Sarah, by the end of the day, we'll hit something.
Judge Judy will continue in a moment.
Mr. Szynski, you came here as a witness today. Is that
Yes.
right, sir? Well, you're going to leave here the owner of a judgment, because Ms. Morris indicated that minimally she thinks the job is worth $300. It's probably worth closer to $600 or $1,000 to do the entire job. But I believe that Mr. Calmetta was not doing this job to be paid. He was doing this job for another reason. However, you were not. The court will enter a judgment, but the judgment will be paid, Ms. Morris, to Mr. Szynski in the amount of $300. Your claim, Mr. Calmetta, is dismissed. That's all.
Parties are excused. You may step back.
एक हरे भरे जंगल में सब जानवर खुशी से रहते थे। हर तरफ दरख्तों की सरसब्जी थी और सूरज की किरणें दरख्तों से गुजरकर नीचे आ रही थी। हाथी, हिरन, तोते और चीते खुशी खुशी खेल रहे थे। परिंदे आसमान में आजादाना अलिफारती हुए चमक रहे थे। जंगल का माहौल सुकून भरा था। फिर अचानक शेर का गिरोह जंगल में दाखिल हो गया। शेर बड़े गुस्से में आकर दहाड़ने लगी। सब जानवर खौफ के मारे दरख्तों और झाड़ियों में छुपने लगे। जंगल का पुरअमन माहौल एकदम खौफ में बदल गया। इसी दौरान एक अक्लमंद पुराना उल्लू दरख्त की एक ऊंची टहनी पर बैठा और सब जानवरों को इकट्ठा करने के लिए आवाज दी। सब जानवर इसके अर्द गिर्द जमा हो गए और इसे गौर से सुनने लगे। उल्लू ने कहा, हम सबको मिलकर अपने जंगल का तहफ्फुज करना होगा। हाथियों ने अपनी ताकत से रास्ते रोक दिए। चीते अपनी तेज दौड़ से शेर को परेशान करने लगे। तोते ऊंची उड़ान भरकर जंगल भर में खबरदार करते जा रहे थे। हिरन दरख्तों और झाड़ियों के पीछे छपकर शेर की नकलो हरकत पर नजर रखे हुए थे। शेर जानवरों की इस मजबूत और मुत्तहिद हिकमत अमली से परेशान हो गए। आखिरकार वो शिकस्त खाकर जंगल छोड़कर भाग गए। सब जानवर खुश होकर एक दूसरे को गिले लगाने लगे और जश्न मनाने लगे। जंगल में अमन वापस आ चुका था। सब जानवर मिलकर खुशी मनाने लगे और एक दूसरे से अहद किया कि वो हमेशा अपने जंगल का तहफ्फुज करेंगे। वो जानते थे कि जब तक वो एक साथ होंगे, जंगल हमेशा महफूज रहेगा।